matter, my lord, with your lordship kindly. I'm filing a memo for posting, my lord. It is a fresh matter. Writ petition, Green Bench, my lord. There is a threat of, my lord, attachment of property. Order was passed on 4/11/2024. Day after tomorrow is the date of attachment. They have informed the jurisdictional police also.
They will inform about day after tomorrow.
Day after tomorrow is the date of attachment.
You are informed
I was informed yesterday.
about day after tomorrow.
Yes, my lord.
Tomorrow.
Tomorrow. Publish.
Matter for admission. The writ appeal, land acquisition matter.
Land acquisition, what is the urgency?
What?
In land acquisition, what is the urgency?
The repetition dismissal, lord, I find the writ appeal.
It
Like
will
10
come.
quintas of land, my lord, I have reconstructed house in the my land.
Sorry, remove the office of, wait for five.
Lord, remote, lord, complied, my lord.
Then kindly wait for 5-6 days.
And now the KDB people, lord, KDB people, lord, officials, lord, they come to the, lord, the land. They are, lord, trying to dispose.
22nd November.
May I request for top of the list, my lord, tomorrow?
We'll take up.
Yes, sir.
May I make a
My
request to your lordship?
This is a fresh matter for contempt, my lord, not been listed, though you have removed the office objection, my lord.
Then wait.
Any date may be given, my lord, any date.
Every time, every matter can't be by
It has been filed almost
9th
3 months.
December. 9th December.
Please,
One fresh matter, my lord. The urgent is, my lord, the matter pertaining to transfer. There is no existence of post,
Which one? Serial number?
not today, my lord. The fresh matter to be posted
Fresh.
last week of filed.
Uh,
There was no post existing. Earlier occasion, this court held, my lord, in the very case, no post existing, quashed. No, my lord, the interim order was there. My lord, no, it is dismissed last week, my lord. It was filed last week, my lord.
It is appeal.
Tomorrow, my lord. Otherwise, my lord, he has
Appeal.
no salary for the last 6 months, my lord.
Appeal.
Appeal.
25th November.
Little earlier because no salary, my lord. He's unable to educate his children. There was an interim order.
25th is not far away. Let us. Not far away.
Tomorrow.
No, 25th. 20th. Or it can be a 22nd, 23rd. 23rd. 23rd is what? No, 22nd.
23rd.
23rd is Saturday.
Then 20th. Because no salary. Otherwise.
21st. Yes, anything?
My lordship, the matter is kept pending.
Yes, madam.
It is WP.
Yes. Well, when do you want? 22nd of November.
The lordship's kind intended just say no, 53, my lords.
Serial number?
53, wherein I have engaged service of senior advocate, is admitted to the hospital.
So what is the request?
Lords,
What is the request? What is the request?
but just my lordship kindly adjourn this case for to some other day.
Urgent, all right. 50, 53,
53.
50,
3.
53.
Raja,
Rate of bill. So it will go to 9th of December.
much of-
Lord, there is a Supreme Court order which has stated the Honorable High Court of Karnataka to just dispose it of at an earlier stage, but no date has been reflected so far, my lordship.
File IA.
My lordship?
File IA. Like,
Yes, my lordship. Honorable Supreme Court has requested our Honorable High Court of Karnataka to dispose it of at an earlier stage. Already 8 months has gone, my lordship. We were waiting for the date.
file IA. With
Yes,
this
madam.
order. Annex this order and file IA.
Serial number 13.
Permit the circulation.
My lordship?
We'll permit the circulation of IA, file IA, and we'll fix the date.
My lordship.
Serial number
23, my lord.
20,
23. 23, my lord.
23.
Here for the respondent.
Any convenient date in the first week, my lords. December.
One second. When do you want? When do you want?
Any convenient date, first week, my lords,
First week of December,
please, my lords.
11th December.
Date.
Serial number 13, my lords.
The request of learned review, you are for, madam?
Appellant.
Appellant, stand over to 11th December.
Serial number 13, my
Serial
lords.
number 99, my lords. I appeal for the respondent number 1. My lords, matter now stands infructuous.
Hmm?
Matter stands now infructuous, my lords. My lords, this is the matter pertaining to permitting the student for government quota, the NIOS student, open schooling student. So now NRI sponsored quota, she has obtained a seat and now she has got admitted.
Learned review, you are, what is,
Respondent number 1, Vinayak Kulkarni, my lords.
no, where is the petitioner?
My lords, when matter is called,
Let it be called out.
great,
In the,
great,
at 2:30 we'll call out.
grateful, my lords. Great.
Serial number
Ask
13, my
the
lords.
counsel for the petitioner to be.
Serial
Ramani
number-
Ranganath,
Serial
Great.
number
13, my
serial
lords.
number 39, my lord, 39.
39. Yes,
Counsel for petitioner, my lord.
pardon?
Counsel for petitioner, my lord. My senior some health issues, my lord, December first week, my lord. My senior some health issues, my lord, serial number 39, my lord.
39, what do you want?
Counsel for petitioner, my lord.
So what do you want?
Urgent, my lord, urgent, my lord.
You're for petitioner,
Yes, my lord,
39.
yes, my lord.
Yes. At the request on behalf of the, you are Muralidhar KB. At the
December,
request made on behalf of the petitioner by counsel. Stand over to 12th of December, 13th of December.
Serial number 13, my lords. I appear for the appellant in this 13, my lords.
13.
Yeah.
Appear for respondent.
I appear for the appellant in this matter, my lords. We are yet to seek instructions in this matter, my lords. May kindly post it in 2 weeks' time. We have already informed the other side and they have no
At the
objection.
joint request of learned council parties, stand over to 12th of December.
My lord, serial number 8. Serial number 33, my lord. 33.
Lordship, I am for the petitioner in serial number 33. Lordship, in this
Suffering
case-
from cold and fever. Short accommodation, please.
Lordship,
And help-
since this is the 4th time they have not filed any reply, in spite of the single judge passing an interim order not to complete with the construction, they have not adhered it and they've gone in ahead and completed the construction as well, your lordship.
So his counsel is suffering from fever. So let it go to 4th December.
Obliged, your lordship.
Serial number 32, my lords. I appear for the complainant in this matter. Arguing counsel is undertaking travel, my lords. May kindly post it in 2 weeks' time, my lords.
4th December.
Please, my lords.
My lord, serial number 8, my lord, appearing for the petitioner, my lord. Seek for a short adjournment. Maybe posted next week, my lord.
No.
Sir, any mention through EC, sir?
Serial number 85, my lord.
85 years.
It is a PIL, my lord. To comply with office objection, 3 weeks time may begin.
No, let it be called out. We'll see. Not now. Yes.
Yes, my.
Time provisions. The contempt matter, still number 1, Mr. Murali Babu M.
That 10 days time to file a complaint affidavit. 10 days time may be granted.
Pardon?
10 days time may be granted to file a complaint affidavit.
Notice already issued. Notice written on 3rd December.
Still number 2,
Same notice written on 3rd December.
3,
Same, 3rd December.
still number 4, Mr. Arun Govindraj.
Appearing for the complainant, not seek 3 weeks time. Seeking
Which one?
instruction.
Which one?
Till number 4, ma'am.
At the request of learned review for the petitioner. Who wants time? Stand over to. Second December. I know, this is child custom. They want time, what can.
Yes, yes, ma'am. Please, ma'am. Obliged.
Serial number 5, may I
Number
request
5.
pass over, my lord. Senior counsel will address the argument. Kindly pass over. Kindly pass over serial.
Pass over not possible. There is no urgency in this matter. If you want
Senior
to
counsel.
argue and come at the time when it's called out. Will not pass it over. So fifth will go to, which date do you want?
20th.
20th. Yes, next.
This is number 6.
Here for the petitioner, my lord. My lord, this is a matter where we have sought that area which was made to be maintained as a park.
Notice
in
written
Karnataka.
alone.
We'll serve the respondents, BDA and BBMP.
Appear for BBM.
If we can. We may be permitted to serve the respondent. It's BDA and BBMP.
3rd December.
3rd December. Great, great.
Grateful.
This is number 7.
Your lordships have filed an impleading application yesterday, your lordship, to the matter.
What about the urgency in this matter?
Now, my lord, that
The same has not been
Function is
reflected on the cause.
supposed to be held on the 17th,
17th,
19th.
19th.
It's on the 17th, Saturday.
17th.
Sunday.
But 17 is holding trial. 17 is trial run. And then
The Kambala is scheduled to be held on Sunday, your lordship, 17th.
That is why, my lord, your lordships had fixed
Here.
it today.
Here.
No, not here, in Pilukula, my lord,
Pilekula Kambala, this
next to
one,
a zoo. The issue there, as I had pointed out to my lords, was not with respect to the geographic location. They can certainly hold it in that area, but not next to a zoo. And I've produced my lord letters issued by the zoo director speaking of the dangers to the animals in the zoo. And it's not only that, now we found out that it's in the perimeter of the zoo. That zoological park has a perimeter, my lord, which has been fixed by the central zoo.
Date the
authority.
pleadings.
Yes, no, it is there.
Earlier a petition on a different line, now it will be in different line.
Yes, yes.
Earlier the PIL was on a different ground.
Your
Correct.
lordship, I
Now
may be,
you are shifting to a new ground.
It is one additional ground which I filed an amendment
Then is it,
application for.
Pleadings are elaborated on that count.
On that count, my lord, I've filed the amendment application. And also your lordships last time said your lordship would allow that application.
That is allowed or not? It is not. Huh? You just remind, it is never come to me.
your lordship,
We have this. We have a copy.
Where is the advocate general? He is appearing.
Yes, ma'am. Advocate General is appearing. And for the committee, I think my learned
Take
friend.
what date? Tomorrow we'll take.
And
Because this amendment-
My lord, the AG is just on his way, my lord. Just 2 minutes, my lord.
Pardon?
The Advocate General is on his way, my lords. Just 2 minutes.
Yes.
He's there. The AG is here.
No, apart from the presence of learned AG. Only thing that
your lordship, I may be taken on board, your lordship.
what is the distance from Jew and?
It is 111 meters.
Well, it does not matter as per the regulations, my lords. What my learned friend read out in the application, my lords, it is within the premises.
It's within the zoo premises. That's the problem.
I'll point out that, my lords.
I'll show you.
And this has been going on from 2014, my lords.
No.
And 2014, for the first time, my lords,
So can we take up at 2:30?
2:30.
So that entire board will be arrested?
Yes.
please,
yes.
my lord.
Very well. 2:30.
Your lordship, The IA that I filed an impleading application, my sole, I'm representing a wildlife conservationist. I took an independent survey of the zoo as well as the Kampala, the location of it. My application has the exact map of the track. I have pointed out the track, the zoo, the distance between it, and the contention that the same is within the premises. Everything is contained in my application.
So there are
But
two,
unfortunately, it didn't make the board. So if it didn't make the board, Your Lordship, it did come on the pause list. If it's taken out 230, the same may be directed to be taken into
We'll
consideration.
hear you.
Yes, Your Lordship.
Don't list it. We'll hear you. We'll hear you.
As a
This
matter of
is-
fact, in this area, my lord, from 2014, it's never been conducted. It's been conducted for the first time after
My lord,
2014.
incorrect statements are being made. I'll point out when it was with photographs, I'll point out it was conducted from 2014, well, by 230.
Anyway, I'm sure my learned friend has better information, but our information is that it has never been conducted for last 10 years. Do it there, my lord. I'm not saying we don't do it there.
The ground now no more available to you that it is to be conducted on the certain cultural part of.
But what happens?
Which the entire, which is why I said, geographically, there's no difficulty in holding it in Pilukula. There's no, I can't even say that they can't hold it. I'm only saying the location where they're holding it is right next to the zoo. Now, my lord, the rights of those animals are also relevant. It is not as if, my lord, it is only culture and tradition. To practice culture and tradition, you don't have to do it next to a zoo. You can always do it 1 kilometer, 2 kilometers away from the zoo, my lord, so that the animals in the zoo are protected. There are reports, my lord, and the zoo director has written to the district administration saying it poses a great danger. There is a king cobra breeding center. There are, my lord, leopards and tigers and lions there. And there are several animals there, my lord, which
all these submissions.
the fear, my lord, of, one second, sir, please, 1 minute. The fear of the noise, my lord, and the Wildlife Protection Act specifically provides for it. We can't not have any objection to holding it in Pilukula. I'm only saying don't hold it so close to the zoo. Hold it somewhere else.
You are not amending any prayer.
I have amended the prayer as well. I've added a prayer.
Copy is not, the petition.
But the amended petition, I'm not.
Not
No,
allowed.
Amendment is not allowed.
Prayer amendment,
Last time.
Not allowed.
amendment in the prayer in light of this proposed amendment is.
Yes,
I think it was allowed on the last day.
your lord said allowed, but it
No,
wasn't allowed.
it has escaped my mind to be candid.
Please,
So
let the amended
No, amended petition is ready. I can hand it over to my learned friend.
it is ready.
Lord, I'll read the prayer.
It stands allowed, not
Yes,
defective. but,
the prayer is issue a writ of mandamus restraining respondents from conducting or granting permission to conduct Kambala in Pulukula in the vicinity of the Pilukula Kambala Zoo.
Well, at 2:30 will start.
Baby. 2:30.
Your application is already there. It is listed today.
There are two amending applications, Your Lordships. One is from the petitioner side and one is from my side.
No, your is there.
Ashwin Putina.
This is by whom?
I believe it is IA number 4.
IE number P of 2004, my lords.
You are Mr. Aswin?
Ashwin, yes, Lord.
It is there. Dakshina Kannada People for Ethical Treatment. No. Where is the applicant's name?
Ashwin Putina. Bhuvan.
Yes, same.
The applicant is Bhuvan M.
Who say it is listed? It is listed. It is listed. So you are in favor of the petitioner or?
I'm in favor of the petition, Your Lordship, but there are certain, I'm
So-
adding on to it.
Don't worry, it is listed, so need not.
Grateful, great.
Still number 8.
The
The
petition,
green bench matters.
petitioner.
Yes. This is only notice you are challenging.
Yes.
So file-
Notice, my lord, demand has been made. They have
Reply,
demanded the amount.
maybe, file reply.
They have not given me opportunity, my lord.
You hear him then.
Yes, my lord. Lord, there are many notices that have been issued. No payment made, but only replies given.
Lord, annexure D is the order passed by this honorable court.
12, 13, 2 వచ్చేది. 12, 13. 13. అర్జునలా. Lord 13 2 వచ్చేది.
Challenge in this petition filed under Article 226 of the Constitution is directed against notice, demand notice dated 28/11/2023, issued by the Secretary Mines and Geology Department, Bengaluru. The petitioner is called upon to pay the amount of rupees 1,19,28,160, which is claimed to have been payable by the petitioner towards dues within stipulated time, within stipulated time. Furthermore, certain lacunas are observed in the functioning of the fore of the petitioner. The notice additionally requires the petitioner to supply the deficiencies and correct the same and cure the same, else, state's notice, the license will be cancelled. The petitioner was granted quarrying lease, public license for a period of 10 years, which was extended for further 10 years. From 10/8/2018. So when the lease expires, 28.
Lord,
This is-
35, my lord, 17/9/2035.
30 years.
For the 10 years,
20 years.
20 years.
18, my lord, 10, 20 years.
So further extended and it expires in
Yes.
the year 2035.
2035.
The extension of lease in terms of the conditions of deed dated 18/9/25. The petitioner has narrated in the petition the history of earlier notices demand notices received by the petitioner towards for payment to royalty, data and etc. Full stop. As far as the impugned notice is concerned, comma, it is the specific ground urged and canvassed by learned advocate, Mr. So-and-so petitioner, that the impugned demand has neither preceded by neither any notice or hearing given to the petitioner, nor there has been a formal determination of the amount claimed to have been due and payable by the petitioner. It was submitted that even in respect of the deficiencies lacuna observed in the notice, the petitioner is deprived of the permission to defend his case. Paragraph. Learned additional government advocate Srimati Milo Akbar was at her receiving end, when pointed out the above aspect that the demand notice came to be issued without hearing the petition. Full stop. The adverse consequences of payment of dues in nature of penalty, etc., have been imposed on the petitioner without affording the petitioner any opportunity to raise defense and put forth its case. A straightaway demand is made by the authorities, asking the petitioner to pay the amount and complaining about the non-correction of the deficiency, returning the cancellation of license. Full stop. The breach of principles of natural justice and not giving any opportunity to the petitioner to defend his case, has vitiated the impugned action of issuing demand notice on the said ground of non-compliance of the tenets of natural justice and not giving hearing to the petitioner, the impugned notice dated 28/11/23 is rendered illegal. It is liable to be set aside only on the said ground of non-compliance of natural justice without going into any other aspect of merit. As a consequence, the present petition is allowed by setting aside the notice dated setting aside notice dated 28/11/23 issued by Tribunal 1. Full stop. The subject matter stands remanded to the competent authority as respondent on hearing, which shall extend the opportunity of hearing to the petitioner, which shall permit the petitioner to file a reply to the notice, and shall also thereafter permit personal hearing to the petitioner, so that the petitioner is given reasonable opportunity to defend his case in respect of the amount claimed as well as the deficiencies alleged. Full stop. A fresh order after hearing the petitioner shall be passed. A fresh order after undertaking the aforesaid exercise shall be passed by the competent authority within a period of 8 weeks from today, and the entire exercise shall be completed. It is clarified that this court has not gone into or opined anything on the merits of the case of the petitioner. The setting aside of the impugned notice and the aforesaid directions are based only on the ground of non-compliance of natural justice. Petition is allowed to the aforesaid extent and disposed of.
Question number 9.
Ravindra Gajana.
Same, this is also same, not, why you are not hearing? Not heard. That is the only ground.
No,
They're
my
not
lord,
heard.
there
Heard or
is,
not heard?
No, my lord.
Not heard.
my lord, to go to the quarry site, one has to pass through the forest land. And so according to the forest officials, my lord,
That's maybe right entirely, but all of a sudden.
Because
visiting somebody with.
main grounds of my attack would be my lords.
my lord, his application has to be considered. It's not that quarrying lease has been granted.
Grant notification has already been granted, my lords. Nil and this quarry plan is approved. Environment clearance has already been obtained. Thereafter, that doesn't survive and it doesn't fall within forest land. Only the contention raised for the third time that it is not passing through a road which has been marked in the documents. But the question would be, my lords,
What is, where is the impugned order?
order at annexure A, my lords.
Page 27,
Uh,
for release application submitted.
Yes, my lords. 24, my lords. 24, annexure A is the impugned order. But the grant notification is
So it is based on the report of the forest department.
My lord, could I just pass on a decision of this honorable court? Paragraph 6 may be seen, my lord, to cut it short. Internal page 7, paragraph 6.
my submission would be, my lords, page number 54 may kindly be seen. That is the grant notification. It is the English typed version, my lords. I may kindly be permitted to read that one paragraph, my lords. The said land is a private land. The competent authority for the grant of quarry lease and District Mineral Administration Authority, Shimoga, has examined the applied area and observed that there are no public buildings, road, water tank, etc. within a radius of 200 meters from the said area, and the proposed area is free from removing building stone. Since the Revenue Department has confirmed with the villagers Mahjar that there is no dispute from the villagers, as it is clear from the letter so and so, so and so. Next, I skip those two sentences, and third sentence in the same paragraph. As the technical officers have submitted a report that the quarry lease area is located outside the minimum distance required to be maintained from the public structure, and in view of the order number so and so dated 21/5/2014, passed by the presiding officer mine so and so, so the department, CN department, the lands falling within the distance of 100 meters from the forest boundary, which were granted prior to 1969, there shall not be prohibition to continue quarry lease. Therefore, it is hereby informed to take suitable actions for grant of stone quarry lease on payment of the following statutory dues. That presupposes that, my lord, this land applied area is not falling within forest land. And
My lord, the road to the quarrying site has to be through the forest land.
no, that's why I have produced annexure N, my lords.
And my learned friend is insisting that there is a road when, my lord, that is not reflected in the map also.
That maps are of 1930 or earlier, my lords. Annexure N is a certificate issued by the Grama Panchayat, wherein it states that 2.5 lakhs rupees has been spent for formation of the road, my lords. It is at annexure N at page number 89, and the typed version is at 90, my lords, page number. I may kindly be permitted to read, my lords. As per the request of Srimati so and so, so and so, being requested for no objection certificate for conversion of the agriculture land bearing survey number 35 so and so, so and so, Hosanagara Taluk, Shimoga district, into non-agricultural purpose, it is certified that there is no objection from the Panchayat for conversion of the agricultural property bearing number so and so, so and so, as per the decision of general meeting dated 19/5/2003, and the land which is requested for conversion has the connection to the road belonging to the Chikkajane Grama Panchayat. Road has been formed by Gram Panchayat, my lords, and it is functional, through which villagers are passing. And the NA conversion was granted in respect of this area, my lords. The factum of non-grant of quarry lease cannot be based on non-formation of road found in the village map.
The senior geologist and competent authority, Department of Mines and Geology. The senior geologist and competent authority, Department of Mines and Geology, Shimoga, issued order of endorsement dated 11/3/24, rejecting the application of the petitioner for grant of release. It is this order passed by this movement for which is thought to be called in question by filing this petition. Paragraph. On going through the contents of the impugned order, it is based on the ground that in order to approach the quarry land site demanded by the petitioner, the only approach road is available which passes through the forest land. In that view, since the forest land is to be entered into, quarry permission could not be granted.
So in the meantime, my lord, I may be permitted to withdraw this writ petition on the ground that without giving me an opportunity of being heard, the senior judge has granted me pass this order, which I will be agitating before the competent authority, my lords. Because this is going to oppose the principles of natural justice. This order is passed.
So you're withdrawing? You do not know what order we are passing, but you are withdrawing, then you are withdrawing.
Because
You are withdrawing. Learned advocate, Mr. So-and-so seeks permission to withdraw the present petition to approach the competent authority. To approach the competent authority.
competent authority may be directed to reconsider my request. Or maybe remitted back to him for fresh orders.
We have different course in mind. If you are withdrawing, then withdraw. Our order will proceed. Don't know where the order will go. We don't know our destination also. In the middle of the order, middle of the dictation of the order. So what is the destination of the order? We don't. Since you are in the middle seeking to withdraw, withdraw.
Because on earlier 3 occasions, 3 forest NOCs were granted. And this is on the 4th occasion, my lord. But this order has been passed without giving me an opportunity of being heard.
So what you are preparing? You are inviting order, or you are permitting us to pass the order which we are going to pass, or you are withdrawing?
No, but maybe referred back to the competent authority for a.
There is no guarantee. We don't know our order until it is completed. Even we don't know the order.
No, because as it is that content, because my prayer is itself, my lord, that the annexure so-and-so, without giving me an opportunity of being heard, before passing such an order, cancelling the petition's QL application.
So what do you decide now? What do you decide? Either you withdraw or we pass the order. What order will pass, that is our job.
My client would be interested in having this Pata land, a quarry lease, my lords. It is not government land. Wherever I'm quarrying, it is a private Pata land, not belonging to the government. And already a road has already been formed by the panchayat investing government funds. I may be permitted to withdraw, my lords. Please, my lord.
This is number 10. And for the petitioners, my lord. Now, my prayer is at page 20. On the ground of ruler parity, my application, the similarly placed person who earlier had approached this honorable court, only one has been granted. And though we have submitted representation, our application for quarrying license has not been considered. Now, your lordship, my prayer at page 20, your lordship may permit it. Issue, may I read, my lord? Issue a writ in the nature of mandamus or any other appropriate writ or direction against the response one to grant the quarrying license in favor of the petitioners hearing in furtherance of their respective applications with annexes A1, A2, A. Yes. Number 11.
Equally, Lord, this is a case of writ of mandamus. The petitioner had filed an application for seeking quarrying lease in the year 2015 itself. Pursuant to his application, NOCs were issued. Despite that, application was rejected in the year 2016, which was questioned in the WP number 2706 for 2017, set aside and sent it back. After that, and then joint inspection was conducted and grant notification was issued, and quarry lease also issued. Not now, subsequently, one more endorsement was issued rejecting the application, which I questioned it in a revision petition. Revision petition came to be allowed and directed the competent authority to consider and pass appropriate order. Not
Why they are not executing the quarry lease?
the thing is, bro, after not complying the certain compliances, recently they have sent a letter.
Where is that?
That is at annexure N page number 98. No?
98.
Please, that is dated 22nd January 2024, under which the competent authority is seeking again opinion of the deputy commissioner in respect of the land which I sought for, which is not at all provided under Rule 8.5. Rule 8.5 is required to obtain NOC from the assistant commissioner. Assistant commissioner NOC that I already produced before this honorable court. Despite that, they are delaying my application for consideration.
So you're asked to obtain no objection certificate? No.
Not done.
Who is asked? Page, annexure N you are referring to?
Please,
Annexure N.
this is the page number 101.
So
Translate.
you are Prakash,
Please, man, he is the petitioner.
petition, Prakash Srikant
In his
Taibaki, application. No objection letter is given by the assistant commissioner. Under rule 2 of the, under reference 2, revenue department so and so have conducted joint inspection, approved the grant. Under rule 3. The joint inspection report is not submitted.
joint inspection report is already produced, not already submitted. And based on that, grant notification is already issued. This is not recently, not the letter is sent to deputy commissioner for obtaining one
But
NOC.
then they are considering your application.
Already,
This is only an internal correspondence from the office of deputy director addressed to the deputy commissioner.
deputy commissioner. Not already, not if at all it is required, it has to be obtained within a period of 90 days as per rule 8.6. I'm not disputing, I am not challenged it also. Not it is sent in the year.
You are not brought into picture so far, as far as this.
It is copy is forwarded to me also.
Letter at correspondence at page 101, you are not in picture.
It is
One
forwarded to me.
authority asking to submit no objection from another authority.
Of course, not. Please, my submission is, this copy is forwarded to me, but of course not, before that already grant notification issued. Once grant notification is issued, they have to go ahead for the further steps. That is my submission. And because there is a time limit to application before T3.
My lord, could I seek instructions and make my submission, my lord?
Especially with reference to the last two paragraphs of page 102. That is the only hurdle
Yes,
in the
yes.
grant of
Yes.
it appears. Everything is there, joint inspection report is also there, but still no objection, something is required. We'll keep it on 19.
And my lord, 19 holidays, my lord, my lord may have it on 22nd.
Or
22nd.
22nd. Learned additional government advocate, Srimati Nilofar Akbar, may take instructions in relation to the grievance of the petitioner, in particular with reference to the communication dated 22/1/2024, figuring at annexure N. into the page 101-102. Put up at 2:30 on 20.
Yes.
12 and 13 are adjourned. Seal number 14, Mr. Abhijit, the writ appeal matter.
I beg to appear for the appellant. The crux of the matter, may I request your lordship?
There is a
to-
delay of 47 days.
Yes, my lord.
So we'll
The-
issue notice.
I will accept notice for respondent 1 and 2.
So any other parties,
Respondent number 3 is,
Respondent number
they will
3.
have to be served.
notice will have.
Notice written along 2nd December.
Second.
Seal number 15, Mr. Keshav M. Datar.
There's a delay of 62 days, my lords.
Notice written on 3rd December.
Grateful. As well as serial number 16, my lords.
16,
16 also, same day, same.
Grateful.
seal number 17,
Your lordship, I am the appellant, your
14%,
Same order, notice written along 2nd December. This is 2nd December.
Obliged, your lordship.
this is seal number 18,
Serial number 18, my lords, your lordships may recollect, this is the matter where for KPCL recruitment, an examination was conducted.
Negative mark.
Negative marking, that's right, my lords. Now, possibly the recent constitution bench judgment in Tej Prakash Pathak, that also may have some bearing because there are some very pertinent observations in that, my lords, regarding.
But here point is that the main examination was taken on the basis of negative marking. The
Correct,
retest
my
will have
lords.
to
We
be-
were not informed. We were not informed, correct, my lords. And when the second exam was
Who were not
conducted.
informed?
I'm sorry, my lord.
Who were not?
All the candidates in the first examination, in the hall ticket, and as well as in the question, the
You are
answer-
for students.
for the students, yes, my lords. For the students. So in fact, what happened was, we wrote the exam sometime in February 2023. Subsequently, my lords, they issued a notification in May saying that there will be negative marking. My only point is this, I am not
That-
opposed to negative marking.
That May notification was in respect of the first exam or retest?
Retest. First exam, when I wrote the exam, my hall ticket told me there will be negative marking. So at least I was put on notice. Second exam.
Retest is an extension of the main test.
That is what but then, my lords, in fact, in principle, that may be correct, my lords, but also what happened in this case is, the second exam was outsourced to the Karnataka Examination Authority. The KPCL has brought on record documents where KEA itself was not sure whether to negatively mark or not. So everybody was kept in the dark. So at the end result is this, my lords, nobody knew that there was negative marking. And result is what, my lords? Result is a completely arbitrary selection. Because, my lords, if I know there is negative marking, I will necessarily.
First test. Condition was there. Conspicuously absent. Those are the conditions. She's absent. Describe the
So what do you want? Time?
No, we are ready.
Take some.
No, I'm told, my lords, that.
Constitution bench judgment is there.
Yes, but that judgment is there. We just place it on record.
Of Supreme Court.
Yes, but it's very recent judgment, extremely recent judgment. This is just
You
before
are also
the.
there.
Please, madam,
For
the respondent KPTCL, madam. KPCL.
In- a copy. Give the copy to the other side.
Okay, the citation.
No, we'll give it. We'll give a copy.
I don't know what he's talking about.
You know, how do you underput it? What did you give me? You gave the compilation. The last judgment in that compilation. On the separate, okay, then.
Appellant.
These principles are well accepted principles. The question is a question of fact, my lords.
Can you see, my lords, has the Tej Prakash Pathak versus Rajasthan High Court.
This is the this is Rajasthan.
Yes, correct. That was referred. Manjushri was doubted because in the reference order refers to another order in Marwaha's case.
But
and
in
said,
this negative marking aspect is.
negative mark is not, but my lord, what is reiterated is that the change in the rules of the game will apply even to the recruitment process. So, and there are also certain observations regarding examinations where.
You are drawing analogy that conditions which applied in the main test should apply in the second.
No, my lord, no, all we're saying is this. As long as there's a level playing field and all candidates were put on notice that in the fresh examination conducted earlier this year, that there would be negative marking. Your lordships would recollect possibly from examination days. If we are put on notice that if I am attempting 1 to 100 questions and there will be no negative marking, I will attempt all 1 to 100. And these are all multiple choice questions. I will take a chance. I may not know the answer to one question. I'll take a chance. But if I'm told that there is negative marking, I will scientifically answer it saying that I may take a chance, I may not take a chance. That's all I'm saying, my lords. As long as a level playing field. That's what this judgment also says. Like although it's a very detailed judgment, kindly see, my lords, at page 30, internal page 36 of that judgment.
33.
Yes, ma'am. 35, my lords, 36.
36.
Whenever my lords is taking it up, my lords, I'll take my lords through the entire judgment. Kindly see para 30, my lords.
Yes.
What is clear from the above is that the object of any process of selection for entry into a public service is to ensure that a person most suitable for the post is selected. What is suitable for one post may not be for the other. Thus, a degree of discretion is necessary to be left to the employer to devise its method, procedure to select a candidate most suitable to the post, albeit subject to the overarching principles enshrined in Articles 14 and 16 of the Constitution, as also the rules, statute governing service and reservation. Thus, in our view, the appointing authority, so-and-so, in absence of rules to the contrary, can devise a procedure for selection of candidate suitable to the post, and while doing so, it may also set benchmarks for different stages of the recruitment process, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before the commencement of the recruitment process. But if the extant rules of the advertisement inviting applications empower the competent authority to set benchmarks at different stages of the recruitment process, then such benchmarks may be set at any time before that stage is reached, so that neither the candidate nor the evaluator, examiner, or the interviewer is taken by surprise. The decision in K. Manjushri does not prescribe setting of benchmarks for various stages of the recruitment process, but mandates that it should not be set after the stage is over. In other words, after the game has already been played. This view is in consonance with Article 14. Of course, this is a very detailed discussion, but this is what I would like to rely upon. Now, as long as I am aware of what I am doing and I'm told that you will be negatively marked, or this is the cutoff. There's no cutoff issue over here in our case. But what the Supreme Court judgment says is this, that nobody should be taken by surprise. And this is precisely what has happened here.
Now, what is their stand?
I'm sorry, man.
What is their stand?
That's what the learned single judge has held, my lords, is one, what your lordships expressed orally some time ago, that it was a re-examination. In the first examination, you knew that there was negative marking. Therefore, you ought to have been put on notice in the second. And second aspect is, having participated, you cannot challenge. The second aspect I'll immediately address. There, the learned single judge may have erred factually because we challenged it well before the select list was even published. As soon as that corrigendum was issued saying that, or a public notice was issued saying that there will be negative marking, we immediately approached this honorable court upon reopening of the court after the summer vacation. So we didn't wait for the list. There is.
You filed the petition after declaration of result.
No, before declaration of results.
Before.
Before.
But after appeal.
After appearing, yes, absolutely. But
When did-
that's what I'm saying. I mean, when I appeared, I was told that, or rather, I was not told that there will be negative marking. So I wrote the exam.
So when
But
did,
afterwards, when I'm told that there's negative marking, that's my, in short, that's my grievance.
when were you told about the negative?
Sometime, I'll just specify the exact date, my lords,
In the middle of the examination?
after the exam.
At the time of publishing the provisional score list.
8th of May 2024, I'm told that there will be negative marking. In fact, my lords, in all fairness, the KPCL has also brought on record
So,
certain documents.
Between the provisional declaration and the
That-
some result, you filed a petition.
Yes, yes. So we didn't know that we were disqualified. But as soon as we were told there's negative marking, we were under the apprehension that this will result in arbitrariness.
Results are declared now.
12th of June 2024.
There was no stay.
I'm sorry, ma'am?
There was no stay. Or
No stay, no stay. Single judgment, intervention.
After the exam, this KE validation, this is KEA, this is by KEA. KEA never conducted examination, intention of.
No, where is the main? You mean main. This is for what post?
This is for assistant engineer and junior engineers and some other posts in the Karnataka Power Corporation Limited.
Any other group of students are here?
There are some.
Any order pass will affect around 9,000 people, candidates, 18,000 candidates, my lords. No. There are 18.
In fact, no, I'm grateful. Manas. In fact, that is what was going to be my next submission, even for the recruiting agency. Manas. Finally, what is their objective? That if they have 400 posts, they want the 400 of the best people. Now, the question, Manas, the recruiting agency may also have to answer is, has this resulted in an arbitrary process, which has resulted in possibly not selection of the best candidates?
No, Your Worship, a question which is ought to be raised in answer to my candidacy. In the re-examination or all examination, there was negative marking. And in the original, the various petitioners who have written the first examinations, there was negative marking. New candidates were not permitted to write this exam. They have written this exam. Everybody else, 16,000 candidates, 1,000 candidates were aware negative marking is there. Only 6 petitioners were not aware. I mean, that is their case, Maloj. That we are not aware, all others.
How do you say so?
Nobody is before the court by this. No, Maloj, if they were aware, if anybody was aggrieved, yeah, I would put it, Maloj, if they had no knowledge, they would have told that we had not knowledge. Your Worship, I can do it 2 ways, Maloj. I'll just point out, I'll get the information also, Maloj. Assuming will take endeavor.
Was there a separate notification notifying the retest?
Yes, it was there.
There was
So
2018.
Containing some conditions about the conduct of the exam?
No, Manoj, nothing.
No.
Same conditions.
Where is?
But may kindly see, can I just take Manoj through the list of dates?
In fact, Manoj, Your Lordship, may I fix it for a date for hearing next week or something, my lords?
No problem.
We'll place.
Whenever you want, we'll hear it.
Any day.
Just
Leave it to my.
Gathering the
Learned
prima
AG, of
facie-
course, is,
Gathering prima facie things.
Yes,
I understand, my lords. My lords, there are two things, my lords. One thing, my
So
lords,
we saw us the notification which was the basis for pretest.
that, my lords, 6/12/23, my lords will find that, sorry, 7/12/23, page 289.
289.
7/12.
Is
289.
289 is not released.
Annexure R3, I'm sorry, my lords has writ appeal 1018. I'm so sorry. My lords has my learned friends. He'll point out the
We
page.
have
89, my lord.
589.
Okay.
So this was the only thing.
Yes,
No,
my lord.
7/12.
no conditions
No
were attached.
condition. In the original
No, my
recruitment
lords, Your
notification.
Lordship may kindly see it this way, my lord. No condition means the same conditions will apply.
That is what we are trying to gather.
Please.
whether- So no conditions were attached.
Yes, ma'am. No, this is the only re-notification. May I just submit this one? The original recruitment notification specified that there'll be a written test, no further conditions. It did not say anything about, I can complete, I will have no case whatsoever if the original recruitment notification specified the manner in which marking will be done. But that did not specify. When I wrote the first exam,
I'll send you. Or.
no,
Recruitment notification.
Second. Come within. First.
Those who have qualified, out the list.
Both,
Sorry.
482.
Clause 7.
Plus 7.
So selected candidates.
correct, absolutely.
Also.
The written test for 100 marks will be conducted in the relevant technical subject. Questions will be of objective type at OMR. The question paper will be the English version in respect of engineering pattern. Only whereas for chemist, chemical paper, the question paper will be both in Kannada and English.
Who appeared in the retest?
Same candidates who
No,
had
no.
written
What
the
was
original
actually
test.
happened was the original examination was cancelled by the KPCL itself after certain writ petitions were filed alleging large scale malpractices. So this honorable, then there was the KPCL itself accepted that there were some malpractices, cancelled the entire examination. That the cancellation was also challenged by certain petitioners. That was upheld by this honorable court before the single judge as well as the division. Then an examination was held in recently, after about 6 years.
So therefore, it
This
is,
is the sequence of events.
therefore, it is only cancelled, permitted only those candidates who were earlier taken to re-exam because of certain discrepancies.
So then, Mr. Vikram, the principle of
Changing the rule of the game.
legitimate expectation would work against you.
No,
To expect.
no, that's what my learned friend just read, which is why I said I would have no case whatsoever if the original recruitment notification, as held in the recent, the 5-judge bench judgment, the original notification can specify, or it can give certain leeway. Now that leeway must ensure that there is nobody is taken by surprise. Now that is what the constitution bench says.
In the original notification, the negative marking. was
It's not there. It is not there.
No, it
Not
was
there. That is what he read. That is what he read.
No.
The examination was conducted. In my hall ticket, I was told that there will be negative marks.
My lord, with great respect, let's be on facts very clear, my lords.
That's what he just read.
On facts, I mean, let's not guide the court. Ultimately, what happens? Original examination, when the petitioners wrote there was negative marking, they were aware of that the negative marking. I'll place material to show that when.
I'm not denying that. Your lordship
No,
asked
they were-
original notification, no. Original exam, yes.
Yes,
That's all.
that's examination. The fact, let's be
That's all
clear.
I said.
So before commencement of you and notified, you instructed that.
Yes, they were
Yes.
part of it. There's no dispute on that.
Then
2017 notification is the original
how
notification.
can you act upon a condition which is not part of the original notification?
That's right.
No, it
That
is
is the
not-
precise point.
My lord, that's on facts, let's be clear, my lord. When they wrote the first examination,
There was also a changing of rule in the middle of the game,
no.
even in respect of first examination.
My lord, that was challenged and that was dismissed. Cancel. So there, my lord. My lords, it is, the first examination was clearly, they have written with full knowledge that there is negative marking. I'll place on affidavit those material and documents. Now, let them not say that we are not, they are not aware. It's, they are fully had knowledge, my lord. And prior to writing of the exam, the rules of the games will change. If it is after the exam, I can't change the rule of the game. That is, if he took the test at the time of taking the test, whether he had a choice to mark it or not mark it, he knew at that point of time. The rules of after the test, if I change the game, I have fairly conceded, my lords, I've changed the rule of the game, which is impermissible. I have no on facts. I will not have. If I'm able to show to your lordships, my lord, prior to writing the first test, what are the rules of the game, that has not been changed at all.
We'll hear rather than concluding.
No, it's a any day, next week, any day convenient. Next week or week after next.
Tell the date.
Learned AG's schedule.
Can I request for 27th, my lords, 2:30?
27th. 27th. What?
My lords, we will, my lord, and I thought that we will not issue any appointment order till the judgment is passed by your lordships. No, the process is, my lord. My lords, we will not issue any appointment order, my lords. We'll go through the whole process. Before with your leave of a lordship, we will not issue any appointment order.
I'm told that
Statement is coming from a responsible mouth. You must trust.
And one more thing,
Could it be on 28th, my lord, instead of 27th? Could it be on 28th, my lord?
28th.
In 26.
My lords, if I may, my lord, one submission. My lords, I filed an impleading application.
That is the problem there. That's
Will not
precisely
be
what my
taken,
learned
my
friend
lords.
was. Now they want to come on
We are
record.
candidates. We are
They are
candidates.
the ones who are there in that list now. If they had not proceeded, this would not have happened. That is the problem that's all I wanted to say. Now, when the AG says he was not going to do anything, we have to trust his word. But the problem, my lords, was on the earlier occasion, an oral undertaking was given that they will not proceed any further. Now a list is published.
Now
They are the ones who have come. Now four third party rights.
List was there much prior to
filing
and
of
any order passed by them will affect them and them, my lords. Both of them. So it's better they come on record, because tomorrow they'll go to Supreme Court saying that we are not heard in the matter. It has affected us in their, and as far as we are concerned, it doesn't matter. We need 400 candidates, which is vacant from 7 years, and 800 vacancies are there. I just want to place the facts for your lordship's kind.
26 at 2:30.
Please. Yes, for tomorrow.
Good.
Cell number 19, Chetan AC.
The final notification of 2007, my lord. Even now, award is not passed. Division bench in another case has set aside such a final notification. Government and KIDB are served, my lord. First time it is coming before the court. Delay of 24. from division bench judgment, they appealed to Supreme Court. That SLP was also dismissed.
So it is after 15 years, good ground to reject the petition.
Lord, that 15 years, we were pursuing other litigations, my lord. That is,
Other?
we were pursuing in the High Court itself. They had filed batch petitions that to consider mandamus, etc., my lord. That was not mentioned here. By that, this law was not there. That the 28th, there should not be delay in passing the award after the final notification. But now it is covered by the division bench judgment, and Supreme Court has also dismissed the appeal filed by KIDB, my lord. So therefore, this is a similar case, my lord. So the delay in passing the award. So my delay in filing the writ petition, that is due to various other reasons of pursuing litigations in the High Court, my lord.
Stated in the petition? Not stated. About delay, you stated something in the petition, original petition.
In the original petition, I had not stated. I filed amendment application. In that amendment application, I stated, but that was refused, and writ petition was dismissed on the ground of delay.
Where is that amendment application?
The amendment application, my lord,
It is filed here.
is filed. Not filed yet. So kindly see page 91, man. Page 91, a memo was filed to withdraw the writ petition and refile a fresh writ petition with making the reasons as to why we had not mentioned the previous litigation. Because she had gone in a batch, my lord, and she was not aware about.
This acquisition was for industrial area. For what purpose? Industrial area development acquisition.
Let me see the judgment.
What were the other proceedings? What were the proceedings you wanted to mention in the new petition?
Lord, she had filed a writ petition along with the others that please, she wanted a mandamus, my lord, from the High Court, that you please consider the representations. And then the KIDB gave an endorsement that, no, we are not going to release this land. We need it, so that in that process, there were two sets of writ petitions. So like that, there was delay till this writ petition was filed. But kindly see this division bench and Supreme Court judgment. Once this is the law, then all those old petitions are of no effect is my submission.
So this accusation is set aside. In the other petitions, what happened in the other petition? In the mandamus petition, what happened?
No, mandamus petition, they gave, finally that was allowed. They gave an endorsement that no, we are not going to quash.
Not going to acquire.
We are not going to set aside this final notification.
Then
But now there is a delay. Final notification is of the year 2007, my lord. No award has been passed. So this division bench judgment, which is Supreme Court has also said that dismiss the appeal filed by the KIDB. There was only a delay of 11 years. But in my case, there is a delay of 17 years now, my lord. Till now, no award is passed. So all the farmers are just left like that without any remedy.
same acquisition. These orders deal with same acquisition.
In not the same notification, some other notification, but similar, no award is passed in that case also.
What is this page 88?
Yeah.
Page 88. What is that?
Page 88, that time she filed one more writ petition. She was not aware of the final notification. She thought only preliminary notice. So that we withdrew with liberty to challenge the final notification and then filed this writ petition.
So here in respect of the delay in award, and in this your case, it is a delay in challenge itself. That makes a material difference.
Delay by them, my lord. More than my delay by them in passing the award should be considered.
You are challenging after 17 years.
No, because I was in the process, I had filed this mandamus along with the batch. I'm a widow. I'm not so aware about these things. I was in a batch. So those proceedings were going on. They gave the endorsement in 2019 or 20. They gave the endorsement. So after that, I filed that.
Tomorrow we are keeping for orders, for further consideration and orders. Tomorrow. Tomorrow.
AIDB served, not represented.
That matter is kept when? Yes. 2:30. This also will get. 2:30.
But respondents 2 and 3, there are 2 more writ appeals filed against the very same order which is posted tomorrow, minutes. Just passing on the
Tomorrow.
2 numbers tomorrow, minutes.
More repetition also made, writ appeal. There is a status quo has been granted, but there is threat of demolition of the building on the site, my lord.
Lordships is
So,
taking up tomorrow,
my lord,
minutes.
The order copy, my lord, the status quo has been granted in that case.
Tomorrow we are keeping.
Tomorrow.
The other matters, my lord, which is
There is
referring to is
threat, my lord.
posted tomorrow,
We have
minutes.
already come to the next strict, my lord. So therefore, they have already started, demolishing the building, my lord. The status quo has been granted, not there, but otherwise, any time, my lord.
So this is for demolition.
Not in case, but same case, my lord,
Yes.
challenging the common
No,
law,
no.
my lord. Writ that is posted tomorrow, my lord. But the order sheet, not I'm put.
So don't, you are a demolition.
Lords,
Yes, yes,
so
my
far as this writ appeal is concerned, your lordships may take my words, my lords. If there is any construction, it will not be touched.
That
Till
may be
tomorrow,
the
my lord,
other-
certainly your lordships
Lord,
may take it as my words.
There are, my lord, they are coming in 2 buses, my lord. They are employing the gundas, my lord.
The council is making a statement.
If there is any construction, I am ensuring, my lord, that that will not be touched. Till
Lord,
your lordships hears
They
the matter,
went
my
to
lord,
the
I will
police
not.
station, my lord.
Shall we record that?
Your lordships may record it.
Can be recorded.
Lordships
See,
may record it.
Since the
Record.
petition is, since the appeal is being posted tomorrow from a learned senior advocate, Mr. Ravi Shankar stated that if any construction exists, it shall not be touched and the status quo shall be maintained.
Yes.
We will
Lords, in
record-
respect of the appellant's subject matter of appellant's property.
Yes,
lords.
In this
no, no,
construction,
in respect of
in
my,
respect of the subject matter of the property of the appellant.
Lordships.
but another writ appeal, same issue, my
Having
lord. That
recorded
may
the
al-
statement, stand over
That may also be related tomorrow also.
to which.
Same issue, my lord.
Anyway, your lordships is hearing this matters, my lords. Once your lordships
That's why
decides,
it
it
can
will
also
hold
be
good for the
taken.
other matter. Status quo, what is referring to
No,
is
no
going to
time
the
to
other
submit.
matters.
memo.
This thing only, I'm saying,
Do
this-
it done at 11.
I'm only.
This time will not. No, we will not breathe this procedure, yes.
Yes.
Tomorrow we'll see if it is permission. Next.
21.
My lords, I appear for the appellant in the connected matter, my lord. I appear for the appellant in the connected matter, my lord. There is one defendant and one plaintiff in the suit. Both have filed appeals, my lord. Both are connected. I am the appellant in 21.1, my lord.
In commercial appeal number 177, I appear for the appellant's counsel.
In my
But,
appeal, my lord.
This is 177 is an appeal by the defendant. Perhaps my learned friend appears for the plaintiff in the suit. But if I
Please,
may
my
say
lord.
so, the judgment is left both of us aggrieved. How the learned judge would reach the conclusion, he makes a suit claim for money, my lord.
May I make one submission regarding service, sir?
We'll accept notice. Please, my learned friend, need not worry. We will take notice on behalf of the defendant as arrayed in the trial court. My lord, no difficulty about it. My learned friend would accept notice.
There is already an order I have served.
No problem. My lord. Let me make my submission on merits. My learned friend is
Yes,
on service. You'll take it that it's
This
done.
has
my
to
lord.
be admitted and heard finally.
Not either admitted. It's also a fit case for remand is my respectful submission. May I just show your lordship 3 paragraphs from the impugned judgment. If your lordships are satisfied, it's a fit case for remand, my lord, it can straight away go instead of say, I only thought it will save time. Because he's also dissatisfied with the judgment and particularly that paragraph. Please be kind enough to see, my lord, suit is filed by him. I, my lord, provide education content. He was to procure schools and he was to get a 6% commission effectively on the sales that he's been able to get for me. This is, my lord, the understanding. There were 3 agreements. 2013, my lord, there is, of course, according to me, there is this inordinate delay and the issue of limitation, which has not been answered by the trial court. That is one of the points I've urged. 2013 was the last of the documents that's executed between us. He says there is a 60-month window I have to pay. Be that as it may. He approaches the NCLT in an oppression petition. Fails.
Section 9 petition.
Sorry, not oppression. Insolvency petition and fails. Thereafter, my lord, he institutes the suit in the year 2021. Notices are issued, my lord, 2016, 17 onwards, be that as it may. Now, please be kind enough to take the impugned judgment. The discussion on reaching the quantum of claim, please be kind enough to come to ink page 80, internal page 32, my lord. I can read from earlier also, no difficulty, but really there is no discussion at all on this. Para number. My lord, may kindly take para 41. Of course, it begins at para 40. Total claim he makes is for 1.25 crores. Please see what para 41 the learned judge would do. Hence, dues for the smaller quantity of work order is 38,000 and original work order is 8,21,000, which is unpaid. Plaintiff has received commission at the rate of 6% to the tune of 26 lakhs and received 11,20,000 under work order 1 and 2. Now, claim in regard to work order 3 is 68.04 lakhs as commission at the rate of 6%. Since it is a huge consignment, therefore amount is reduced to 3% and it comes to 34 lakhs. Looking at the relationship between the plaintiff and the defendant, since it is a service matter, moreover, the plaintiff is a service provider, he has rendered service. Please mark the next sentence, my lord. There is no commercial transaction. Hence, plaintiff is not entitled to interest. Therefore, I answer, my lord, if it is not a commercial transaction, the commercial judge should have just dismissed the suit or, my lord, returned the plaintiff. He had no occasion to then entertain the suit. This is my first submission. Second submission, how does he reach these numbers, my lord, is beyond anybody. In fact, perhaps even my learned friend would struggle to justify how these numbers are arrived at. How does a learned...
Why there is no commercial transaction?
This is what the
dispute as the pecuniary concept also.
Yes, it is above that. It is definitely above 3 lakhs. According to me, all I'm submitting is that this conclusion is something that baffles me, my lord, as I'm sure it baffles him. It is clearly erroneous.
So you are saying that there is no commercial dispute involved?
To be honest, I don't think we even raised the dispute of it not being commercial. That's not what our contention is. I'm just saying that this conclusion would run and militate against, my lord, the conclusion in the judgment. This is one part of it. My lord, even keeping that aside.
It is a service matter in what sense?
My lord, what happens is, may I just take a minute and point out, I have, my lord, developed some education content for schools. He says he will procure various schools as customers for me. And when he procures them, I am to pay him basis the sales of my content, my lord, the commission. This is effectively the arrangement. But even as per the claims made in the suit, my lord, the
Commercial court.
please be content to look at section 21C.
The contract of agency.
It is not an agency contract. It is really more in the nature of a service that he provides, or rather, he procures customers for me, my lord, and I pay him a commission.
It is under both, my lord. Both are covered under the provision of services and agency contracts are covered under 2(1)(c), my lord. And it is not the case in the
Small Roman 18.
Service contracts are covered under 2(1)(c).
Yes. Yes, my
Please,
lord.
my lord.
18, my lord.
Eight-
Roman 18.
18 is service, so falls under agency as well, my lord.
So then,
More fundamental point. There is absolutely no reason assigned by the learned judge to reach the conclusion of why he says 38,000 is payable, 8,21,000 is payable, 34 lakhs is payable. The entire conclusion is completely whimsical. And according to him, it is wrong because he should have got more. According to me, it is wrong because I should not have been liable to be paid anything.
I'll
Been
make
made
my
liable to pay anything.
submissions.
This is, my lord, let me complete, sir. I mean, my learned friend is too anxious, but let him just. This is, my lord, one that I wanted to point out. Please then be kind enough to see paragraph 43, how the learned judge deals with limitation. Even under the plaint, invoices go back to the year 2013, all the way till 2017-18. For services rendered, according to him also, in 2016, he issues a legal notice. Then none of that is considered. Please see what he would say. This is in regard to the point of limitation is concerned. Defendant company has taken a defense that suit of the plaintiff is barred by law of limitation. Decisions relied upon by the learned counsel for the plaintiff referred up come to his aid. What judgments is not mentioned here. It is admitted by DW1 in his cross-examination that there is time of 60 EMIs. It is for all three agreements. Therefore, that this is all the reasons or lack thereof insofar as limitation is concerned. Plaint averments, my lord, if your lordships are kind enough to notice.
I'm ready, my lord. Please, my lord. If I may invite your attention, my lord, to the impugned judgment where issues are laid out. That would be internal page 7, my lord, paragraph 4.
That is in page 55 of the appeal compilation in 177.
There are 12 issues that are cast, my lord. If I may just identify the issues and whose burden each of these issues were placed, my lord. Issue number 1, 2,
then
3.
let the record be there.
It is called for, my lord. It is called for in the
It's
previous.
called for,
Please,
it's
my lord.
available. All.
Please, my lord. Issues number 1, 2, 3, my lord, are plaintiff's issues. Regarding the first issue is with interest till the date of filing of the suit, my lord. The third issue is with respect to filing of, with respect to pendente lite interest, my lord. In this, my lord, I have been granted partial portion of the prayer number A, my lord. I have not been granted prayer number 2 and 3, my lord, issue number 2 and 3. After that, my lord, from 4 to 10 are defendants' issues, my lord. All the arguments canvassed by my learned senior counsel has been answered by the court. I will show your lordships on which page and based on what exhibits they've been answered, my lord. The issues that were pressed briefly in the arguments, my lord, are issue number 5, my lord, and issue number 7, my lord. Issue number 5 deals with, my lord. Please, my lord. Issue number 5 deals with non-existence of exhibit P6, my lord, which they contest that is not a binding agreement. It has been answered in my favor. If your lordship looks on next page, my lord, paragraph 7. The issue is whether the defendant proves that agreement dated 26/3/2013 neither exists nor holding any legal enforceability is answered in my favor on the next page, my lord. The issue of limitation, my lord, is also considered. This is issue number 7. Whether the suit is barred by limitation, again, it is answered in the negative, my lord. The reason why I have filed appeal, my lord, is only with respect to all the details of how the judge has arrived at conclusions on each of these items, my lord, is accurate, my lord. Only paragraph number 40, my lord, is rehorse any evidence, my lord. It is just at the whims of the judge, my lord, which, if I may say so, without any evidence, the amount which is 6% throughout, my lord, and which is noticed in the previous paragraphs of the judgment as well, has been arbitrarily reduced to 3%. Other than that, my lord, all the other points are answered very accurately, my lord. If I may point out to the two arguments raised by senior counsel, my lord, with respect to limitation and with respect to commercial transaction, my lord. If I may invite your attention to the paragraphs where they have been considered in the impugned judgment, my lord.
Paragraph?
My lord. My lord, it starts from paragraph 14, my lord. If I may be permitted to read, my lord. In
Sorry,
further,
it appears your lordships don't have the records, my lord. Should we, perhaps then we should either wait for it, or even if you have to refer to the plaint, perhaps your lordships don't have the compilation. Sorry to interrupt, my learned friend, but I think the court master has not been able to locate the records.
So we'll take up, let the record be here. Come on, 28.
28th. I'm sorry, 28th, some difficulty. Could it be 29th or
Any other date?
please?
Then 3rd, 2nd,
3rd December, please.
3rd.
3rd December.
So keep with this record.
my lord, may I be permitted to tender?
Because this first appeals will take time.
It will take a little bit.
I am tendering objections to the appeal in, I am a respondent, my lord. 21, I am tendering.
What is there in appeal?
Just
What
pointing
is-
out where the arguments have been considered. I have not produced any
My
document.
learned friend is trying to supply reasons that the learned judge has not.
No, I'm just answering the grounds taken in the memo of appeal, my lord, not necessarily saying.
But on the last occasion, there was an oral understanding that there'll be no precipitation, my lord. That may please be great. Third, so grateful. The court master could just request that the records are placed, because otherwise unnecessarily again.
Have the record and keep with.
Please.
My lord, service may be noted as complete in my appeal.
My learned friend just told me he's got instructions to file wakalat in the companion appeal.
In 21.1, it's my appeal, my lord. I have served as well.
So
But the-
notice to be issued.
It is served, my lord. It is.
My learned friend will take notice, he'll file wakalat. I made that submission. There's no difficulty. Grateful.
This number 22. The Dalwai Venkatesh.
By the defendant. But so suit has been declared against me. But the recovery period, my lords, for supply of goods to the defendant appellant is from 2013 to 2015. My lord, that is ends on November 2015. My lords, exhibit P112. My lords, is a sale deed executed by the appellant before your lordships in favor of the respondent for settlement of entire dues amount. May I just pass on, my lords, a document which is part of the exhibited list for admission purpose, my lords, I thought. This is dated 4/11/2016. My lord would please turn to page 5. In page 5.
Admit appeal.
Where?
Appeal admitted.
Lords, I sought for interim order.
Deposit the amount. Money decree.
Lords, I understand, but the lordship may kindly, page 5 of the document which I passed on. It is admitted document between the parties. His claim is between 2013 to 2015. This is, sale deed is executed on 4/11/2016. Please see, my lords, the consideration part, page 5, in page 5. Thus the buyer, your lordships have adjusted the entire sale consideration of for 49,60,000 by way of a settlement claim of the buyer in respect of the material supplied, in receipt of total consideration so and so. The seller hereby acknowledges and confirm towards the entire sale consideration as mentioned in full and final settlement of the sale consideration, and confirm that there are no amount due outstanding from the buyer to the seller in this behalf. The seller hereby conveys and so and so. So as on date of 4/11/2016, whatever the transactions which were existed between the appellant and the respondent before your lordships, stood settled by conveyance of this property. Now, if the plaint claim is to be seen, my lord would kindly turn to in page 18 of the judgment. The period pertains to, suit claim pertains to 6/4/2013 to 24/11/2015. In page 18, my lords, internal page 3 of the order, judgment of the learned trial judge. Bottom, your lordship. In page 18, internal page 3, last line. As per the purchase order supplied iron and steel, plaintiff has supplied the same from 6/4/2013 to 24/11/2015, totally amounting to so and so. This is a suit claim. He says that, my lords, after this, there was some additional supplies made, therefore the claim is not satisfied. But that is not the case before the learned trial court. He has written the material worth of 13 crores, 13,82,000 so and so. Payments made totally amounting to 8 crores, 39 lakhs.
29 on 29th. It is to just go into the merit. 29th.
But still then, my lords, EP may be deferred, my lords. Records would be necessary because around 100 documents are there.
On that they will see, they have filed execution.
They have filed execution. The warrant was issued, movable warrant was issued. They can defer it, my lords, for 2 weeks so that I am ready for final
Take
disposal.
time in the.
No, my lord, because subsequently they have purchased the items. It is now almost 1 crore 90 lakh is due. And the subsequent to the execution of sale deed also they have purchased. They have acknowledged and admitted the transaction.
That
It
is
is
not the
sale deed. Subsequent also he is categorically admitted in the cross-examination.
But subsequent purchase is subject to this appeal.
No,
Yes, my lord.
No. It is not. He says that entire material transaction is up to November 2015.
Only sale deed, your lordship, the purchaser, the vendor is acknowledges that there is no due in respect of particular transaction. Not it is covered entire the suit transaction. It is only in respect of 49,60,000. It is the land is assessed for the purpose of 49,60,000. It is not the entire sale transaction between the plaintiff and defendant. It is the defendant, he himself admits that there is no due in respect of the plaintiff's claim. So there is no substance in relying upon this document.
The suit transaction ends on November 2015. Suit is not filed for subsequent transactions for which he has already instituted 138 proceedings. So the cutoff date is that as on 4/11/2016, the entire dues are settled. Lords, your lordship, to secure the record, there are admissions made by him in the cross-examination.
We'll consider. No? Get the, after, if need be, we'll call for the record. 29th.
Records are called. Records are called.
On that day, we'll see.
Very well.
23 urgent. Number 24 miscellaneous first appeal arbitration matter.
My lords, I appear for the appellant. The appeal is under section 37 of the Arbitration Act, my lords. The two stretches of land pertaining to the.
Everybody appears.
No, my lords.
Notice written upon.
My lords, I sought for an interim order, my lords. The appellant is ready to deposit 50% of the enhanced amount, my lords.
32 for two applications, 34 have been dismissed. What is the award?
The special land acquisition officer had fixed the award at 1,61,880%. My lords, the arbitrator has enhanced it to 1,81,306. Totally, the enhanced amount would be
excluding the interest, it would be 16,89,472, my lords.
But copy of award is not there, sir. Is there? Is there?
My lords, SLO's award is not produced, my lords, I'll produce. My lords, at page 58, my lords, the award passed by the SLO is at para 13, my lords. It is available, my lords.
Page?
Page 58, my lords. Internal page 4, my lords. Totally 1,61,000 was the award amount, my lords. We had passed the award considering it to be a commercial land. Again,
The
the
notice written on 2nd December.
complaints in contempt matters, seal number 25. Maitri.
My lord, in this, they have filed a compliance affidavit. I need to reply to the same, my lord. I request for a week's time.
4th December.
Grateful.
Oblation. Number 26, please, my lord.
This is a public interest litigation in respect of forest land. There are two applications that I have filed. I have filed an application to implead certain respondents and for amendment. But the applications arise in this context. But after filing of the public interest litigation, respondent number 41 made an application seeking to implead. Respondent number 41, my lords, claims that certain forest land has been allotted to them, to respondent number 41. Those papers were made aware to me. Therefore, my lords, I have now made an application to implead the official respondents who granted forest land to respondent number 41. And my lords, I have made an application for amendment in respect of that grant seeking to quash the orders of grant. There is, my lords, an interim order until further orders in my favor. The counter filed by the state practically, my lord, supports me.
I appeal for the respondent number 41, my lord. As far as the impleading application is concerned, I have no objection.
Impleading it.
No, I appeal for respondent number 41.
It is an impleading.
Impleading application, I don't have any objections.
Where is the application?
Lord, impleading application is listed, my lords, as IA number 2. It is filed, my lords, on 15/7/2024.
You already granted. So you want to add 42 and 43?
Please, my lords. Because respondent number 41 seems to have received some forest land through 42 and 43.
So that can be granted. This
Please.
IA number 1 of 24.
No, it's I2 of 2024. IA number 2 of 2024.
IA number 2 is the impleading.
2 of 2020. The only prayer is to implead. One, to break it. The district commissioner, Bengaluru district, Kempegowda Road, Bengaluru, and two. Rajiv Gandhi Housing Corporation Limited. To break it, through its managing director. take it over Kaveri Bhavan, Bengaluru, has responded 42 and 43. Full stop. In regard to the subject matter of the controversy, it would not be said that the respondents are strange to the controversy. In any view, it is the domain of the plaintiff as to petitioner as to whom to be included as a respondent. In the circumstances, IA number 2 of 24 is granted. Respondent 42 and 43 are permitted to be included to be shown in the area of respondents.
Not for the very same reasons, IA number 3 may be considered, my lords. IA number 3 is an amendment application to seek the grant order in favor of respondent number 41 also to be set aside.
I find my detailed objections, my lord. So, IA number 3, amendment application.
We can grant the objection merits you can file.
Please.
The only heard learned counsel with respect to parties, the only prayer in this application is to permit amendment in the memorandum of the petition. The contents of the amendment and the prayer sought to be incorporated have clear nexus with the controversy involved in the petition. Full stop. In the circumstances, the amendment could be granted, the same is granted. It shall be carried out within 10 days.
Please, grateful.
Petition may be
But
listed.
amended petition may be directed to be filed, my lord. Amended petition.
The amended petition shall be filed within 2 weeks.
Please,
Put up the present appeal along with the amended memo after 3 weeks. In the second week of December.
Obliged.
Number 27, Tejas SR.
I appear for the petitioners in this matter, my lord. I seek an adjournment in this matter, my lord, on the grounds of personal inconvenience for the.
This PAL.
IA number 1 has been filed seeking directions to respondent number 7, my lord. Their directions for certain checks to be done regarding the scheduled property, my lord. My only fear is I won't be able to adequately assess this honorable court, my lord, which is why I'm seeking an adjournment.
Very odd petition, Mr. Why you are seeking to? Upcoming pub.
Yeah, prayers have to be seen. No prayers, cancellation of all the excise licenses.
My lord, this writ petition has been filed by a conglomerate of resident owners of Indranagar, my lord, seeking several directions to the respondents for violations of several acts, my lord, which is the BBMP Act, the Karnataka Municipalities Act, as well as certain other bylaws, my lord. There has also been violation of the excise rules and the act, my lord. In that, there was a interim order granted directing the Commissioner of Police and the Deputy Commissioner to file status reports regarding certain of the respondents, which has been done in the year 2022, my lord. For that, we have filed an affidavit explaining the lapses in the status report. Additionally, we've also filed an IA seeking for directions to the Commissioner of Police, which is respondent 7, to file a fresh status report, my lord.
Status reports have been filed time and again, my lord, and they are seeking for cancellation of excise licenses that have been granted. And those licensees are not parties before, my lords.
So what do you want time?
Indeed, my lord.
December 11.
Much better, sir.
Obliged.
Pending for the petitioner.
Huh?
Lord, Respondent number
I
4,
took test.
my lords, I'll file my objections to the main matter and the IA, my lords. May kindly be taken up anytime next week. My lord.
But the matter is very urgent in nature, my lord. Lord, the certain lands were acquired for the purpose of establishing the golf course, my lord. Lord, whereas a condition was being imposed with respect to the roads, my lord, which passes through one village, which connects from one village to another village, my lord. My lord, respondent number 4 has encroached the public roads, my lord, thereby preventing the villagers to pass by.
Lords, I'll file my detailed objections. They are ready. I'll serve it on my friend right now.
16 December.
Much obliged.
Yes.
29, Mr. Krishna S. Vyas.
Point number 2, my lord.
Consider the representation, my lord.
In this matter, my lord, they're seeking mandamus to stop the widening of the road. One more writ petition filed before the single bench of this honorable court, writ petition 24006 of 2024. There they have challenged notification issued for preliminary as well as final notification. In that matter, a wide order dated 2nd September, there is an interim order filed by the temple itself.
Temple
Matter pertaining to temple.
The respondent number 5, my lords, I appear for respondent number 5. We have preferred a writ petition wherein this honorable court was pleased to stay the notification itself. That is writ petition number 24006 of 24, my lords.
So what happened to road?
My lord, this is just to consider the representation, my lord. My lord may see the prayer, page 14.
They are not challenged the notification also in this matter.
Reply is filed.
My lord, it's only to consider the representation given to the Union of India and to the National Highway Authority of India.
Actually, in this matter, my lord, as far as they have made respondent number 2 as a national arrest, not coming under jurisdiction of NHA. It is under the jurisdiction of PW department, state only. Ministry same one, Union of India one.
What you are proposing? You are for respondent.
Pardon?
You are for one of the respondent?
Yes, one of
Who
the.
is for petition? Nobody is there. Why you are wasting time?
Krishna S. Vyas.
Learned counsel for the petitioner was not present in that view. The witness to be adjourned to come up next on 9th December.
December 30, 1 PM.
What happened? The closure of.
Settlement did not come through, my lord. We had offered some amount. But then they did
They
not
offered
accept.
5 lakhs as one-time settlement. That, my lords, after working 26 years, 30 years in the institution. 5 lakhs and walk away.
Because I don't have. Closed my department. ACT has given, my lord, the permission. Everybody has.
Filing a memo. We have got documents under RTU, even from my lords AICT. Till today, I am shown as faculty member in the institution in 24. And not only that, we are also showing when this automobile engineering and industrial production stopped, they closed. Most of the professors they have accommodated in the other departments. We have the chart, we are showing their own chart, except us. Lordship just sees, we'll file it. Now for 1 year, my lords, I am without salary, without my lords, at 52, nobody will give me a job also. My lords, I am in 50s. I have taken house loans. I have actually sold one property to clear the loan. Today, I'm in that situation. My
The
lords.
second matter is also same.
My lords, there are two writ petitions. I think it's
Yes,
connected and a
So-
common judgment.
Two professors.
Please.
Both are not to be taken back because of closure of same department.
One department. The learned single judge asked them to take us back. Now, my lords, from December, we are out
itself
of the
is not maintainable. St. Mary's and so many other
Ben
judgments.
Mary's, we can distinguish, my lord. That's the,
Apart from that, the Supreme Court has time and again held, my lord, if the department is closed,
This is, where is the judgment? And this is against,
a private college, my lord,
petition was against which?
Malnad Engineering College.
my lords, St. Mary's dealt with CBSE school, which was, my lords, regulated by a society.
The Justice Parivada's judgment will apply.
That is the St. Mary's which they rely. We also relied on that. But that is pertaining to CBSE, where the court says it's a society. my lord, Central Board of Secondary Education is only a society. Here it is the AICT regulations which govern. Otherwise, my lords, at 51, 52, if they suddenly throw me out of a job for a closure, and please see, we are filing a memo, my lord. Almost 99% of people who are in the same branch, two branches which they closed, they are all accommodated.
Wherever it was possible, my lord, we
Lords,
have done that.
I-
It's not that, my lord, we wanted to, my lord, simply. It's not possible to accommodate them because, my lord, their entire, my lord, there are no department, my lord, where we can accommodate them. That's our problem. We don't have any grudge against anybody. Wherever it was possible, we did.
When they took approval from AICT, they said we'll be accommodated.
Oh, my lord.
When VTU gave them the NOC for closure, it said it's subject to government approval. Till date, there is no government
Please
approval.
look at the AACT order. Doesn't say all that, what my learned friend says.
Committee.
246, my lord, is AACT order.
But 289 is their letter to AICT. That is important. When they wrote to AICT seeking permission. The NOC.
So this is a discharge simpliciter. Discharge simpliciter. It will not affect the future employment.
No, my lord, certainly not. Definitely not.
What is your qualification?
Lords, MTech, PhD. One is MTech, PhD. The other one also is MTech, PhD.
And
And-
you are working in which department?
My lords, automobile engineering.
Both are engineering department.
Automobile engineering. And my lords, I have put in, both of us have put one of us have put in 26 years, 5 months service. The other one 18 years in the same institution.
Not possible to accommodate in any other department.
My lord,
Done it.
Where same.
we tried. In fact, my lord, that's what of course, my lord, my instructions are these. Again, my lord, if your lords want me, my lord, again, my lord, put across and find out. Not that, my lord, we are rigid. But then We did tell them, we tried, my lord, accommodating whoever was possible to be accommodated, my lord, we have accommodated them. It's not that, my lord, we have anything against them.
Today, there is no other department.
No,
where
my
this
lord, where
qualification-
they can be accommodated. That's our problem. But if your lordships feel, my lord, then give me a week's time again, my lord, I'll put it across and then again come back to your lordships. I understand, you know, the
Brother says, and I join that the qualifications which they are holding, if they could be good enough for any other department, you consider.
Hmm. Committee was formed. Once more you try, all right. My lord, we'll try again.
They are not getting any monetary benefit.
Nothing, my lords.
No, my lord. No.
In fact, my lords, the bank has taken up, I have been declared as a NPA. In fact, they gave an NOC at that point when I took a housing loan to build a house. Today, my lords, the bank has put me, that's why I had to sell some ancestral property. Now I'm clearing that loan. Because bank classified me as a NPA. That's the situation in which a professor is. My lord, these are professors. My lords, I can understand. Other than that, they have nothing else to do in their life.
In fact,
It's a
professors
frequent-
can be accommodated, they can go to any other institution if they are so highly qualified. There's no difficulty at all. Today,
Very fact that the others are accommodated.
my lord, others are accommodated because, my lord, they were able to be accommodated. It's not possible to accommodate them because, my lord, automobile engineering, my lord, it's not feasible at all. Automobile engineering is a specialized subject. That's our problem. But, my lord,
Any other?
give me 2 weeks time. Let me again, my lord, put
What
across
is the age
again.
of retirement? 58.
58, 58,
60,
60, 60, 60.
When do they retire? 58.
Lords, we have prepared a chart. I'll pass it on to my
Right,
learned
give it to me,
friend,
let me see.
which
All
we
right.
want to produce, where they have accommodated almost everyone from automobile engineering and IP, both the branches which were close to other branches.
Let me see. We are an unneeded education institution. We also have our problems. Running, my lord, today, engineering colleges, my lord, people are not coming. Law colleges, my lord, are increasing by abundance. There are about more than 100 law colleges, my lord, in Bangalore, and they are increasing, my lord, day by day. But engineering, my lord, students are not coming. That's our difficulty. Anyway, my lord, my learned friend has given this. I'll again put it across. One more, my lord, attempt, my lord, we will make. If it's not feasible, my lord, we'll come back to your lordship.
May I just pass this on to the court? My lord? The same copy I've served on the other
They've served it.
If your lordship doesn't up by
What is interim order granted?
My lord, that stay of the order passed by the learned single judge. They were already relieved. They did not ask for, my lord, they said, don't terminate. They have already been terminated before, the writ petition itself was filed. And the department was closed. Department, my lord, there are enough judgments of the Supreme Court where they have held that if the department is closed, my lord, then they can't be accommodated. But in spite of it, my lord, we tried our best. Whoever possible to be accommodated, we did. Then
That's committee, when they wrote to AICT, before committee took a decision of the college, before writing to AICT, that these people will be transferred. That's the impression they gave to AICT.
with the greatest respect, my lord, that is not so. I'll point
Committee's report is, anyway, my lord, we can find out, we'll show that is the case.
Shall we record something? No.
The lords may call this after 2 weeks. Let me see, my lord.
Next week, next week, your lordship, my lords.
Next week is, let them consider. 2 weeks they will need it. At least 10 days they will certainly need.
All right.
So we'll keep up to 2 weeks. Today is what? 11th, 12th,
Today's 12th.
2nd or 3rd December.
Please.
Whichever date you want, 3rd or 2nd.
Third, my lord, was Tuesday because, please, great.
Okay. May I just pass on this memo with documents which are.
Interim order to the extent.
Interim orders will continue, 10th or to 3rd or
Great.
both 30 and 31.
Please.
Seal number 34. The Venkatachalapati, yes.
The accused in this matter, my lords. My lords, I have been
Even to understand that the compliance has been complied, my lords, I'll place the affidavit. It's a week's accommodation.
25th at
Please.
2:30.
Please.
Number 35. Is Sophia.
I'm for action. Okay. 2 weeks time may be granted to file. 2 weeks time may be granted.
2 weeks time.
My lord, the objection, the respondent was supposed to file its objection.
This is, what is the, where are the directions?
Yes, my lord, it was the direction of Honorable Family
Page,
Court.
page.
Yes, my lord. Page number 10, my lords, of my petition. Till the disposal of IA number 2, respondent is directed not to enter into marriage as referred in IA number 2. My lord, the IA was posted for orders on 22nd, my lord.
Madam, which directions are under contempt?
Pardon me, my lord.
Which is the direction about which the contempt is alleged?
My lord, page number 10 of my petition, my lord, the Honorable Family Court has passed an order on 15/4/2024.
15/4/20.
Yes, my lords.
File my objection, my lordship, reply. The petition itself is not maintainable. 2 weeks time may be granted after.
So what direction do we comply with? There is no direction.
My lord, I have filed the contempt, my lord, because there's a violation of this order, my lord.
She has entered into marriage.
Where is that direction? So he is entered into merit. He.
Yes, my lords.
Who wife has entered. In.
Yes,
No,
my lord.
he's denying the relationship, my lord. She's not a wife. That is, they have filed a conjugal rights, sir.
What you have produced to show that she is married?
My lord, before the trial court, I have produced the temple receipt photographs, my lords, to indicate that the marriage was solemnized between the petitioner and the respondent. My lord, till the disposal of my application, the respondent was directed not to enter into marriage. The
File my
respondent
objection. 2
waited
weeks time may be
till
granted.
22nd.
2 weeks time may be granted, madam. File my detailed
2
objection.
weeks is too long. File on 27th. 27th.
Issue number 36. Radhanandan BS.
Complaint by means. Been instructed to take notice, my lords. 2 weeks accommodation.
There's a positive direction to change the khata in the name of the petitioner. That is the order passed.
I've been instructed to take notice, my lords. I'll file my wakalat and the compliance.
Notice is not issued.
No, my lords, I've not filed the
Notice
wakalat. yet.
written on 9th December, Learned Zone.
Notice was issued long.
That
not-
notice is already.
Notice was issued, my lords. I have to file my wakalat, my lords. Today I've been instructed.
That only file the reply, my lord.
Learned Advocate so and so appears on behalf of BBMP.
BBMP, my lord.
Respondent BBMP and wants to file wakalatnama seeking time on that count from a stand over to 4th of December.
Please. Great.
Hello. Number 37. Tanu Paranali.
Order has been complied, my lords.
We have the complainant, my lords. They've
Complaint.
considered a representative.
I'm placing the
Both the learned councils. Learned council with the respondent stated that the order and the contempt is complied with. Learned council for the petitioner complainant would not dispute the statement of fact of compliance in that view. And in view of the memo dated 12/11/24 filed by Learned Advocate for Respondent 1, producing endorsement dated 28/9/24 on record, evidencing the compliance of the directions of learned single judge, the present contempt proceedings are disposed of, will not survive. Grateful. The memo shall remain on record.
Number 38.
For the, excuse me. my lord,
Rita
it's
Ram Rao.
complete. We have completed the order passed by this.
Who appears?
This is Rita.
Keep back 230.
Please.
Urgent, seal number 40. Mr. Subramanya Bhatia.
Number 39.
39, my lord. I didn't mention.
Somebody must have mentioned.
Pardon, my lord?
39. Already date is given.
13.
Lords, we have complied with the order, my lord. Serial number 39, we have complied with the order, my lords.
39, somebody mentioned. Who mentioned? You are for complainant.
Please, my lord.
It is complied with.
Please, my, it's complied, my lord.
Learned advocate for the
I'm
respondent.
filing a compliance affidavit.
Mr. So and so produces on record the affidavit of compliance. Evidencing that the UGC pay scale is given to the petition.
Please, my lords.
The necessary orders are produced along on record along with the compliance affidavit. Paragraph learned advocate for the petitioner, Miss so and so was not in position to dispute the factum of compliance of the odd directions of learned single judge. Paragraph in the above view, the contempt petition does not survive. The petition is disposed of accordingly.
Much obliged, my
Much
lords.
obliged.
This is number 40. Mr. Subramanya Bhatia.
Representing the petitioner's counsel.
Not to be challenged.
Validity of Act number 1 of 2019 passed by the government of Karnataka is under the challenge before this honorable court. Straight away, I can take to honorable court, wherein preamble portion runs into 4 pages. Act consisting of 3 sections. Hence, holding that the judgment passed by this honorable court is being nullified.
What was the judgment?
My lords, this honorable court has come to the conclusion, I mean, it has 2 or 3 rounds. Conclusion is like this. So far as the appointment to the government appointments are concerned, the process of selection and the reservation, a procedure is already there under the rules. And that procedure is not being followed by the government. And this honorable court has come to the conclusion that this is the correct procedure. I can explain it, my lords, how it has to be. Let us say, my lords, in respect of Group A and Group B post by the KPSC, there will be a reservations to the OBC, SC, STs, and the other groups are concerned. And my lords, for the purpose of qualifying, there will be preliminary test. Then, my lords, there will be the main test. Then there will be viva voce. What this honorable court has said is, till the viva voce is concerned, they will remain in their original cadre, original list. And final list will be all the, whether it's a reserved, unreserved, or anybody, they will be put into one lot. And the merit will be selected first. And after that merit, according to the reservation, the quota has to be fixed. That is the gambit of the decision of this honorable court. However, now the government is of the opinion, or government has formed the opinion to the effect that for every test, in the sense, for a written test, there will be one thing. For a, what is the second test is concerned, there will also be a reservation. For calling for the viva voce, there is also a reservation. In the name of, it is about 250 pages. Orders are there which has been confirmed by the Supreme Court also. In the name of this reservation, or in the name of this process, the most of the things, seats have been taken out from the general category, and thereby they are depriving the general candidates from contesting the process of selection. That is the sum and substance of the whole order as such is concerned. My lord, I can. Leave it.
My lord, the learned advocate general will be coming, my lord, some other day.
Let him come. Today.
No, my lord, not today.
Annexure H, page number 439 is the act. May whereas the different ratios are being followed in the process of selection of the candidates for preparing the list of candidates eligible for written competitive examinations, main examination, and the manner of preparing eligible candidates for personality test in accordance with rule. Whereas nowhere in these rules have specified the method of preparing the list of candidates belonging to scheduled caste, scheduled tribe, and backward classes. Which is prima facie illegal because a specific pages have been mentioned pointing out the rules, government order, etc. by the division bench of this honorable court. They say that the area is not being covered. It is not so. The rules are there, government orders are there, and that has been interpreted by this honorable court. Para number 106, my lord, only for the purpose of immediate reference, my lord, to say so that how the prima facie it is inaccurate. Immediately, my lord may kindly turn to para number 106.
Mr. Will,
please.
Here in the presence of learned advocate. When?
My lord, first week
In
of
all
December.
matter, which year? 21 matter.
First week of December.
Only a pure question of
Law.
second, third, fourth,
Any day, my lord.
4th December.
Obligement.
For 41, to Gautam AR,
Final order.
41, to Gautam.
I undertake to file wakalat for the fourth respondent, my lord. I've been interested by the party today. I'll do it in the.
My lords, the petitioner advocate had just called me to inform me, my lords. I'm told he is not well, my lords. Mr. Gautam Mayor.
In fact, the petition more or less has become infructuous. Respondent number 4 has subsequently approached this honorable court. This honorable court granted order in the nature of a relief to the BBMP officials and to the respondent number 4 regarding illegal construction, encroachment, those aspects. This honorable court said, not by this honorable bench, by learned honorable single judge of this honorable court, would say to conduct a survey, then report, and thereafter take action in accordance with law. That order was passed by this honorable court. I think this petition would become infructuous.
So your interim order is there, after that not happening.
Subsequently, petition was filed.
Lord, please, my lord. I am
Subsequently,
appearing for
what
the
which
BBMP,
petition?
my lord. My lord, I just have these 2 copies, my lord. I have just got this, my lord. I may be permitted to file this along with a memo, my lord, subsequently.
Same property.
Please.
Same property.
Same problem.
Then what remains?
Lord, sir, just one submission, Lords. Lords, I'm not on record. I'm appearing on behalf of the advocate for the petitioner. Lords, he just informed me that he is not well. So any day, tomorrow also, my lords, in his presence, because I am not aware of the facts of the case.
We are aware.
Please, my lords, I know. I'm only submitting that I'm here just to inform that he's not well, my lords. We're requesting for any short accommodation.
Where is he? Where is your counsel?
My lords, he just informed me that he's not well, my lord. He's not well. I'm told he's not well. He's not feeling well.
Who appears?
Mr. Gautam Mayar.
Mr. Senior Counsel appeared, my lord, on the last occasion.
We'll wait. This petition is also not well to survive. What counsel will do? Why are you bothering him? The subject matter gone to this court and dealt with. It is infectious. Anyway, we'll accede to your request. When the council will be able to come?
It's next week, my lord. Next week, my lords, or tomorrow day after.
While learned advocate, Mr. So-and-so will point out that in view of the subsequent developments, the subject matter and the grievance in the present public interest petition has become infectious. Learned advocate, so-and-so requested for time on the ground that the council who will be conducting the petition on behalf of the petitioner is in indisposed health. Stand over to
I'll leave to my lord.
25th of November.
Please, my lords.
To be listed.
I'll inform.
Grateful.
Number 42.
Lord, I am for the respondents 1 to 5.
Lord, in this case, I represent the petitioner's counsel.
Lord, the petitioner's grievance was that there are some illegal occupants who have occupied the national monument and that they're carrying on some activities. And he had sought for a direction to us, the respondents 1 to 5, to take action. Lord, our stated position on record is that yes, indeed, there are some illegal occupants who are carrying on unauthorized activities.
It was a madrasa.
Some people are carrying on some madrasa activities there, which is we have declared it as a monument of national importance. So they're carrying on some cooking and other activities, which they cannot. The only reason why we did not take action is it may lead to some law and order situation. But if your lordships would direct, my lord, the 5th and 6th respondents, were the state authorities and the Deputy Commissioner of Mandya district, then, my lord, in terms of section 16 of the 1958 Act, we can take some action.
15.
Section 58, 1958 Act, that is the Central Act.
My lord, what has happened is, my lord, Juma Masjid in Sri Rangapatna is declared to be, my lord, an ancient monument according to the petitioner. My lord, according to, my lord, the Waqf board, my lord, it is a Waqf property. My lord, and there a madrasa is being run. And now they are seeking for removal of the madrasas. Now, on the last date of hearing, the Waqf Board council was present.
Who is seeking?
I am
petition?
present, my lord. I am
Yes.
present. I am appearing online. If my lord would permit, I will submit. my lord.
Petitioner is seeking removal of madrasa.
Yes.
It is a valid madrasa which is going on from prior to independence also. Right from the time this mosque has been there, it is a living monument. And under the Monuments Act, my lord, a living monument, it says what was going on that can continue. And these are teachings which happens for some time. We have filed detailed objections. Lordship may fix a date, my lord, I will come personally and submit the matter. And the respondent thereafter conducted an inspection. And the respondent, the archaeological department has seen and they have given reports of what is happening there. Young children who come to do namaz, not sit for some time, they will learn something and go back.
Which section you say? 50.
16.
16 on 6.
So that prayer grande, you consider the.
My lord, this mosque was brought in to be a Waqf one in 1963. It is run by another trust, my lord, called the Jadid Masjid.
It is declared monument or not?
Yes.
My lord,
In 1951, we have declared it as a national.
Yes, Lord, there is no
it's
dispute
brought
on
under
that.
the Waqf Act. My lord, she
This
appears
is
for the
the-
Waqf Board.
This is subsequently declared as Waqf under the management of the board. And now both acts have to reconcile. The archaeological department has come and cleared it. We have taken all permissions under the act. These activities are allowed. But I can show that your lordship may have it on Friday, my lord. I will. I request your lordship may have it on Friday, my lord. We will assist the court, my lord, with all the documents. Because my
My lord,
learned
it
friend,
belongs-
sorry. My learned friend, my lord, who just now is submitting, told in the morning that they are going to seek time. And that's why I was not present personally.
My lord, the mosque now belongs to Tipu Sultan Shahid Waqf Estate, my lord.
Who has filed reply?
My lord, the Waqf Board has filed the impleading application to say that the mosque has now become part of the Waqf Board. It's no longer declared as a monument because of, my lord, the communication that was had between the Archaeological Survey of India and this Tipu Sultan Shahid Waqf to say that they have been in occupation, my lord, for a very long time.
A property being a Waqf property
Yes.
and also declared as monument. Is it a conflicting position?
My lord, that I wouldn't know. The Waqf Board.
No.
No, it cannot.
My lord, the
Once it
Waqf
is
Board
a
has to
national
clear this, my
monument,
lord. The Waqf
nobody
Board
else
has
has a
to
right.
clear this. The Waqf Board has to clear this query which my lord has put forth.
Lord, I am
How
happy to do
how
that.
it has become a Waqf property, the Waqf Board has to explain to my lord.
No, even if we admit, we go with your say or Waqf board say that it is a
Yes.
Waqf property.
Yes.
Doesn't strip it of the character of protected.
Yes.
My lord
Yes,
may
my lord.
consider that, my lord, when we argue it on the next date of hearing.
Lordship may keep it on 16th, my lord. We will argue detail. We have
There
filed
is
a
no-
detailed statement of objections
There
also.
is no inconsistency between two status. It may be able to reconcile even if there is.
That's
So
right.
But
therefore,
there is no
section 16
inconsistency, my lord. We will show
section
that.
16 Section 16 powers cannot be taken away.
No, that is right, my lord, but the Waqf board will have to trace whether it was an ancient
for-
monument or not.
You are for Waqf board.
I appear for Waqf board, my lord.
You are in the center of the control. And you are silent. I said, she is a oh, sir, she is for impleading.
Yes, my lord, I appear for the
Imperious, my
Waqf
lord,
board.
maybe
my lord.
You are
implead.
for petition.
But
Yeah.
I represent the petitioner's counsel. But I have been requested to make a submission that he is not keeping well.
We'll just
Lord, 16th, if I may
do
request,
some
my lord.
research and come. Waqf board is, shall we grant the Waqf? Why should we grant the application of Waqf?
We have
My lord,
objections.
to give a quietus to the entire contention that is being raised, because anything, my lord, any order is bound to create law and order in Sri Rangapatnam. So we want to give it a quietus, whatever order my lord passes with the Waqf board before my lord, my lord, it's acceptable.
It is registered, it is in the Waqf register.
Yes,
Yes,
that
Lord,
is
it
what
is
they
registered.
contend.
And it is registered, my
Lord,
lord, pursuant to an inquiry,
Lord,
full-fledged
our
inquiry
gazette
under the
notification is
central
dated
registration.
29th November 1951.
Your notification.
Our gazette notification declaring it as a monument of national importance. The moment we declare it, it becomes a protected monument.
It is
And
a
nobody else has
protected
right over it.
monument. But it is a protected monument. Oh, if they want to take care, my lord, under section 15, they have to enter into an agreement. Such an agreement, the archaeological department has not entered into. But we will show all that. We have filed detailed objections. We will show all that. Your lordship may have
No,
from
all
15.
this, the
we will show.
Waqf board claims are subsequent to 1951. They are not sustainable in law.
From the act, we will show, my lords. The lordship will also see the the stand of the central government suddenly raising in this issue. For 51
No,
years,
we have
they
been very consistent. We have taken a stand on affidavit.
75 years, they have
We
not
have filed
done
a detailed
anything. my lord.
affidavit.
You held.
We have filed
Now,
on behalf of
after
respondents 1 to
petitioner
5.
files an,
We have filed
after
a detailed
petitioner
affidavit.
files
We
a
have produced
petition.
copies of the gazette notification. We have produced photographs. So our stand has been very consistent.
On 25th, 25th.
Yes,
You may take up at 2:30.
very well. I'm ready.
Your lordship would give as any other convenient day before 25th, my lord, 22nd, my lord, Friday, if my lords, it's convenient to my lords.
You on 22nd?
22nd, my lord.
No, there is some inconvenience that day, my lord, not on any
22nd.
other day, my lord.
20th, my lord, if my learned friend is available.
20th is fine.
19th.
20th is all right.
Okay.
20th, 20th, 20th.
28th or 20th. No, that is 20 or 28, my lord, 20.
20, my lord, or 19th if my learned
20.
acceptable for 19th, lord, if it's subject to convenience of the court.
19th is too early.
20th
Very well,
is all
my
right.
lord. 20th, my lord. 20. 20.
Lord, we have filed a detailed affidavit, lordship.
We'll go.
File, my lord, detailed affidavit. And my lord, kindly see, 2 respondents are having a contest before and petitioner is nowhere in the picture.
Only reason to adjourn is that we must have our reflection.
Yes,
proper.
my lord.
That
Yes,
was-
my lord. 20th will assist the court. Obligement.
Yes.
So number 43.
Lordships, I appear for the petitioner in the matter, Your Lordships. I appear for the petitioner in the matter, Your Lordships. Order dated 27/5/2024 may be kindly looked into, Your Lordships. Order dated 27/5/2024. I've sought written the nature of mandamus. This honorable court heard the matter and issued notice. While issuing notice, Your Lordships, in para 3 of the notice may be kindly looked into, Your Lordships. My only grievance is I'm seeking writ in the nature of mandamus to issue Form C license in favor of petitioner. The para 3 is very important. The authorities have taken a stand. If your lordships could see order dated 27/5/2024. Para 3. Authorities have taken a stand that survey number 185 situated at Hangaranahari village 27/5/2024.
Yes, read it.
Para 3, your lordships. Or I'll read the entire thing. The petitioner intends to establish a stone crusher unit. In this writ petition, interconnected prayers are made. First prayer is to direct the respondent authorities to consider the application of the petitioner for grant of Form C, treating the property on which the petitioner wants to establish the unit to be a patta land. The second prayer is grant certificate for stone crusher unit in view of the application of the petitioner dated 18/9/2018, made for the purpose. The third prayer is direct the respondent authorities not to treat the land as forest land or as a deemed forest. The authorities have taken a stand that survey number 185, situated at Hangarahalli village, which is now being claimed by the petitioner as a deemed forest, and therefore the petition and the stone crusher activity could not be permitted in the area. It's actually not petitioner, your lordships. It was a contention of the respondent at the para 3. The learned government advocate so-and-so invited the attention to the court to the communication dated so-and-so from the Department of Mines and Geology, which indicates the stand of the authorities inter alia, and a report was submitted by the Forest Department stating that the original survey number 400 is deemed forest. That's the original survey number. My survey number is now 185. And the report was to be submitted in this regard. Notice to returnable on 19/6. It is the last paragraph, para 6, your lordships. It's directed the respondent shall file necessary affidavit placing on record their stand about the land being treated as a deemed forest and subsequent factual developments, including the report, which may be submitted to the authority. Looking into the matters, controversy, so and so. Lordships, now I am seeking only a writ in the nature of mandamus to consider my application, which is filed as on in the year 2018. Till today, there is no report. At page number 119, may be kindly looked into. It's a joint inspection conducted by the Department of Mines and Geology, where they say it is a patta land. They themselves have admitted in the joint inspection report, where they issue, when I file my application, they have to consider my application, and a report is filed on 3/9/2021. Page 119, Annexure P, your lordships, the translated copy. Page 119, your lordships, Annexure P. Wherein the deputy, the range forest officer is also a party to it, to the joint inspection report. Para 100, page 119, your lordships, the land status, your lordships, clause number 5, patta land.
It is a forest land.
It's a patta land, your lordships. They themselves, this is a joint inspection. It's not my inspection, your lordships. It's joint inspection report filed by the Deputy Director of Mines and Geology. Sorry, Deputy Director of Mines and Geology, Mandya. And at 121, who is the signatories?
The joint inspector's report conducted on 3/9/21 shows it to be a patta land.
And
My lord,
signatories. at
119 in my copy that they have given is my lord, a letter by the range forest officer to the senior geologist dated 8/4/2022.
Where is that?
I don't have that, my lord.
119.
Please take my copy and give me your copy.
Yeah, sure. I'll make available the copy.
My lord, this may be called after 2 weeks. I apologize, my lord. I didn't know.
Lordships, the reason is since it's only a consideration of my mandamus, your lordship, to issue Form C license. That's all. I'm asking to issue a Form C. It's a Form B1 is issued to me. It's an obligation by the Deputy Director.
Let the government advocate satisfy ourselves.
My lord, very well. No, seeking it as a matter of right, I really don't understand, my lord. I have to get instructions to know what this thing is about, application, what has happened. Straight away, I'm asked to say, consider, give me, consider, give me.
Lordships,
December.
the order is of June, your lordships. That's why I'm requesting. We are in December.
Please give me
almost
your copy and take this
a
copy.
date may be given, your lordships, at 2:30 if it could be.
One submission.
5th December.
But
Much.
please may I make one submission. That item 96, not, that's a matter where one of our military units near Ansur Lake, the National Green Tribunal passed an order without hearing us that we have to pay 2.7 crore without hearing us. I have challenged it before your lordship. There is a threat of disconnection of services. We train 2,500 soldiers there. It is at 96 on the ground that some wakalatnama is not filed. My colleague has filed the MA. if it can be taken up at 2:30, my lord. There is a threat of disconnection of services to an army unit where 2,500 soldiers are being trained every day.
It's a fresh matter.
Fresh matter. Fresh matter. It's a fresh matter. It's gone to 96 because the office raised an objection that wakalatnama is not filed. But my colleague has filed memorandum of appearance for all parties.
My
That
lord,
is
Mr.
Union of
Mahesh
India.
Chaudhary's presence is required here.
Tomorrow.
Oh, yeah.
Tomorrow.
Obligement.
Tomorrow in the fresh matters list.
Remove the office.
It's removed, my lord. The office objection is that he has not filed wakalatnama. Yeah, but he has filed memorandum of appearance. Bro, there are three petitioners, Union of India and the two army units. The first petitioner is Union of India. Second and third are the army units.
It's appeal. Petition.
It's a petition, writ petition. You filed wakalatnama. For all three, my colleague Pramod has filed memorandum of
I
appearance.
just think because pollution matter.
That memorandum of appearance is available at page 132. That is for all three petitioners. But office objection is you have to file wakalatnama. So I'm not that.
So how Union of India is directed to?
Yes. We are not made parties because
State
in-
is also there.
state is there.
Some lake in Karnataka.
There is a lake here close by called Alsur Lake. The issue is of discharge of some sewage water into it.
We'll just go through and then
Yes.
tomorrow.
Yes, please, the office objection may be overruled.
Office objections are overruled. The writ petition may be listed tomorrow.
I'm grateful.
We'll take up.
Please, my lord. May I, my lord? Serial number 59. Serial number 45, my lord. No, 45.
Not on previous. Not on previous. If we have to- Evening.
Right. Serial number 45, my lord.
Grant,
Yeah.
get
May I, my lord?
December 11.
Serial number 59, please, my lord. 59. It may kindly be taken on 14th, please. Other side council is also present. Serial
What is it about?
Serial,
What is it about?
so it is regarding a contempt matter. Contempt matter. Contempt.
For-
Serial number 14, please. Sorry.
Same matter, 15. The office objection is.
Serial number 45, my lord.
Office learned counsel
Limit
said the
and
office
some
was
other-
complied with. The office shall verify and then put up the case for admission here.
Serial number 45, my lord. Today I filed wakalat along with no objection of the previous council, my lord. I seek some time to file my statement.
We get the time. Get
My
the-
lord, serial number 47.
ಏನ್ ಹೇಳಿದ್ರು?
Yes.
Pass over matter, seal number 7.
In this matter, my lords, it was scheduled to be held on 17th. It is not being held on the 17th. Can I request, let them implement the Pellicular Development Authority,
17th is going to be,
not going to be held.
not going to.
So let them implement the Pellicular Development Authority, my lords, on whose director's letter, as well as the DC Mangalore, again because they are proper and necessary party, they have not made them as a party. Lordship may have it on 26th, 27th, my lords. Then you'll, and let note.
Information what we have is that they are holding a trial race on 17th.
My lords, election is there, that is why they're not going.
Not holding anything at all. If my learned friend's statement is there, I'll take it, my lord, because the newspaper reports have very clearly
No,
said.
they can't go by, if last time also they went by newspaper report in Bangalore. Again, they're going by newspaper report where after instructions are making a statement, my lords.
The Lordship, adding on to the submission made by the learned senior counsel, that trial is being conducted. It's something called as Kodi Kamla. Kodi means trial in Tulu. So
If they want us to conduct, we'll conduct, my lords.
That is being conducted. That is
But if the AG is saying it's not being conducted, I'll take his word.
even the information as far as I've also got it that it's being conducted. A specific direction may be given, nothing to be conducted on that.
No,
Required to be recorded.
not required, my lord. I don't understand. Your lordship, if they have, let them file an affidavit, I'll file a reply to that. If that is the case, they want to take a stand, let them file an affidavit that they're going to hold it. I'll file a reply to that. No,
Statement can be recorded, no. If you
when
want.
you
I'm saying I agree with what you're saying. I'm not
No, I'm
distorting
saying-
what you're saying.
So then
Why are you
what-
getting offended with it? So can we say that?
They're not going to do that. No, because he has to give instruction what he's going to do. Because he's conducting the. No, he has to instruct, so he has to give a report, Let the concerned Pellicular Development Authority, my lord, because it is in their vicinity which is being conducted, their report will be required, as well as the DC who's conducting the this Kambala, my lord, let him also be implicated. That
I'm sure, my lord, the learned AG knows that the state, my lord, has to first give permission under the amendment to the act.
Going to be held at which place?
Pellicula.
Pellicula.
PILLU.
PILUKULA.
PILU.
PILI.
Pellicula. PILIKULA. KULA. K for kangaroo. man.
Pellicula.
Pellicula.
the original petition was supposed.
Amendment.
The present petition came up today for consideration.
And hearing. Hearing and consideration. In light of the amended pleadings permitted to be inserted in the memorandum of petition. As per order dated 5/11/2024, passed in IA number 2 of 2024. At the time when it was taken up, Learned Advocate General Mr. Sushikaran Setti submitted that the petitioners need to join which of
The Pilikula Development Authority, my lords,
Pilikula, P-I-L-I-K-U-L-A, Development Authority.
and the Deputy Commissioner Mangalore.
Deputy Commissioner Bangalore as well as Pilikula Development Authority as party respondents. Since the issues are raised and the controversy relates to proposed holding of Pambala event at the place called Pilikula. Full stop. At the same time, Learned Advocate General stated that no event in relation to Kambala is going to be conducted on 17th.
Yes.
And until the next date of hearing of until the 17 and on 17th, which was a date earlier proposed. Full stop. Learned Senior Advocate Mr. So-and-so, petitioner, seeks permission to join the Commissioner, Deputy Commissioner Mangalore and the
Deputy Commissioner Mangalore
and the Pilikula Development Authority as respondents. Permission is granted, the course titles will be amended accordingly. In view of the above statement that no event relating to Kambala is to be conducted on 17th or in near future thereafter. Come on. The petition.
Your Lordship, may till then, give a date, man. Thereafter, we'll be holding it, but not before the next date of hearing, man. Not before the next date of hearing, any date your Lordship may give after that.
On 17 and until the hearing of the petition.
No.
Full stop. When at the joint request of learned parties.
20th or 21st, man. 20th.
20th.
One submission, filed I number 3, to implement myself, Your Lordship. I'll get in the ground reality of what is happening.
You are there already, not implemented.
I'm not impleted, Your Lordship.
He'll pass the order.
Yes, Your Lordship.
कब रखेंगे? 20th?
Please, man.
20th is what day?
20th is a Wednesday.
20th is Saturday, Friday. No.
Wednesday.
November, sorry. 20th is okay. That is ideal, 20th.
Wait.
True. 20th. Great. So which is your IA?
I number 3, Your Lordship.
So to be granted, implement. Who are you?
I'm a wildlife conservationist, Your Lordship, and a localite as well. I've undertook a study of the enclosures and as far as the Kambala is being conducted.
Small family is happy family.
It's only,
Anyway.
my lord, so it will be only a problem to your lordships.
Well, very well, we'll permit it. Grateful. Permitted.
Complete.
Number 38. PC Sita Ram Rao.
For the accused. No, it was passed over.
What is this?
No, we have completed the order passed by the.
This is complied.
We have
Where
completed.
is the? Representatives will decide memo of compliance.
Now we have passed an order, my lord, directing him to,
In his favor.
please, my, please, my lord, it is in his favor, but not fully, my lord. Partly it is allowed.
But where is he?
Mr. BC Sita Ram Rao. Mr. Anup Sita Ram Rao.
Learned advocate Mr. So and so for the respondent. Places on record. Along with the memo dated 12/11/2024. A copy of the decision taken upon representation of the petition dated 6/11/2024. Is directed thereby that the supplementary agreement shall be executed.
Please, ma'am. He has to come and execute the supplementary.
Full stop. Directions given by Learned Singh, paragraph in paragraph 5 of the order dated 13th June 2024, which are the subject matter of contempt petition, are thus complied with. The petition is liable to be disposed of and the contempt proceedings deserves to be dropped. Paragraph, the presence of learned advocate for the petitioner was awaited in vain. In that view, put up at 2:30 on tomorrow, 13th. When he comes, we'll dispose.
Please.
It's seal number 99. Iti Pramodini. Vinayak Kulkarni.
None is present for the petitioner, none is present for the appellant. Though the appeal was kept specially for hearing. Send over to 5th December.
Is 101. So, Bola Vedavasa Shinai.
For the complainant.
Why it is kept it?
My
It is
lord, sir.
complaint.
But on the last date, my lords, they had made a submission. They had given a
Few of the my lords complainant were taken on the services what my colleague has made a submission the last date of hearing, my lords. My lords, my humble this my lords, out of the 24 my lords, 9 complainants are before this court. Out of my lords, 5 members my lords have taken on the work, my lords. The date of my lords taking of service is also mentioned. Lords, out of my lords,
So it is.
9 complainants now, my lords. 5 complainants, my lords, have been taken on different dates. my
24
lords.
respondents will be provided.
My lords,
24 respondents will be provided.
My lords, in fact,
my lords,
they have, what they have been doing, my lords, they have not given any order of appointment. What they are doing is, these are all daily wage laborers, my lords. What happened was, my lords, if briefly I may explain, in 2010, 82 daily wage laborers were removed from employment. They approached the labor court. Labor court asked them to be reinstated. The accused files writ petition challenging the labor court order. In that, they say 24 respondents will be given, my lords, appointment. But, my lords, what they have done is every 6 months, they're asking them to come and sign the attendance register. Till now, no appointment order has been issued. The counterparts have been given continuity of service. They're getting good salary, my lords. These are all Group D employees.
My lords, now, my lords, out of the 9 complainants, 5 are working. My lords, let them file an affidavit, my lords, stating that they are not working. My lords, they are working.
Where is the appointment letter?
My lords,
Where is the appointment letter?
my lords, I'll produce, my lords. I have given the details, my lords, of what date they have been appointed, date of joining, my lords.
Directions
At
of
page
the
number
single
4.
judge was that 24 respondents would be provided employment within 2 months, full stop. There is a serious dispute about the conduct of the employer.
My lords, I have
in-
given the dates also, my lord.
In reinstating the, say, 24 workmen, full stop. Though it is claimed that they are taken back, it is the submission on part of the complainants that they are not being permitted to work, nor are permitted to sign the muster roll, full stop. In that view, the compliance could be confirmed only if the respondent employer files on record the reinstatement orders, which may have been given to the 16, to the 24.
That's only 9 are before this court. my lords. Only 9 complainants are before this court, my lords.
9,
Please,
9, not 24.
please.
Could you produce the orders?
Out of my lords, 5 have given, my lords. 5 I'll place it down. Please, my lords.
9 order is there, then you are per the content.
But some more time is given, my lords. I'll try to ascertain for the entire 9 persons also, my lord.
You must some formality you have undergone while reinstating. Produce that.
Please, my lords.
In fact, my lords, what happened was when this contempt was pending, they filed a review petition saying that none of them can be given appointment. I'll produce the order, my lords. And now they're in this proceeding, they're saying they've been given appointment.
When you will file?
2 weeks, my lords, because my lords, remaining 4 also, my lords, I try to ascertain. And
2
file.
weeks? So it means that you have not given any order.
My lords, I'm saying with respect to my lords, another 4 persons who are not in the list. My lords, I'll try to ascertain for that
They are
also, my
concerned
lords.
with the 9 petitions.
So that, my lords, the entire issue may be solved. So, my
So
lords,
there is no other issue except 9 petitions. For, it may be for issue for you. For this court, in this contempt petition, 9 persons to be reinstated, who are amongst 24.
2 weeks, my lord.
9 appointment orders, reinstatement orders, or any formality you might have undergone while calling back them in service or taking back them in service should be produced. 10 over to 25th of November.
Please, my lord. Bless you.
Number 102.
Hearing for the respondent. It's from 7th, my lord, the matter is urgent today, as my lords.
That limitation is.
Yes, ma'am.
This is absorption and seniority. My lord, I would like to place on record, last time I had said the GC, Governing Council, has already taken a decision.
Now, what is your say? Let us see to.
Please,
Please.
Just remind us.
my lords, if lords kindly see, my lord, the order, my lords, in writ appeal. Annexure A, my lords, page number 14. Page number 20, my lords, the relevant direction.
So it is 28th of February.
Yes, ma'am.
Yes.
Small Roman 5, my lords, in para 9. But page number 20, my lords. We direct the state government to consider the case of the appellant for absorption in the cadre of assistant professor in accordance with law as expeditiously as possible. The decision shall be taken by the state government not later than 1 month from today, which shall be communicated to the appellant. Specific direction was that a decision to be taken should be communicated within 1 month. What happens thereafter is that, my lords, the state, my lord, issues an endorsement. Specific direction, my lords, is to the state. State issues an endorsement. My lords, I have filed, my lords, counter affidavit in pursuance of, my lords, what the state claimed, a status report. That, my lords, I have produced, my lords, certain documents. My specific submission is that, my lord, there is continuing wrong on the part of, my lord, the state. If lords kindly see, my lords, my counter affidavit, my lords,
Kannada version at page number 21, my lords, the English version at page number 24. If lordships kindly take, my lord, the English version at 24, relevant, my lords, would be at 25 minutes.
Page.
Lords, English version, lords, of Annexure D. I start, lords, at page number 24. Relevant, lords, at page number 25 minutes.
25.
25. The lords can see, lords, they claim, as per the Karnataka Civil Services so-and-so rules, so-and-so has been reabsorbed as an assistant professor in nephrology institute, and she is continued in the institute. Thus, I am directed to inform you that the government has taken necessary steps to implement the order of the Honorable High Court in Writ Appeal 81 of 2020, and a new government order will be issued after the meeting of the Governing Council. They said, we have taken a decision to reabsorb. We'll issue an order after the Governing Council meeting is held. But I was assured that there's going to be reabsorption, and that order will be issued after the holding of GC. My lord, the Annexure E, my lords, is the proceedings of the GC. My lord, the English version, my lord, starts at page number 31, my lords. If you lords kindly see, my lords, page number 34. Translated version. Last paragraph, my lords, in 34. In the light of the Honorable Court's order, the proposal, it should have been not absorption. Her institute and sent her seniority was presented to the Institute Administrative Board. The board decided to submit the proposal to the government as per the decision taken by the board. The directors and the member secretaries of the Administrative Board of the Aforesaid Institute informed that the Honorable Chief Minister of Karnataka, the President of the Administrative Board, the Honorable Minister for Medical Education and the Vice President of the Administrative Board, the Director of Medical Education and the members of the Administrative Board of the Nephrology Institute would provide clarification in the matter. They instruct the Minister, Medical Education Vice President of so-and-so, to take action according to the existing rules, as there is no provision to consider the service seniority retrospectively. Though, my lords, the translation is not happily worded, my lords. If the Kannada version is seen, my lords, I'll just read, my lords, and my lords, I'll try to, my lords, explain. They say, my lords, page number 30, first paragraph. They say there is no provision to retrospectively absorb her. But the issue was, my lords, submitted to the, my lords, Vice Chairman of the Institute, who is none other than, my lord, the Minister for Medical Education. The matter was placed before him. If lords kindly see, my lord, the extract which I have taken from the file, my lords, under the Right to Information Act, page number 37, my lords. Type copy, my lords, also have produced at 38.
Page 31 is what?
My lords, GC resolution, my lords, of which is in Kannada, my lords, translation I have produced.
So what does it say?
It says, my lords, we have taken the decision insofar as absorption, but there is no provision for retrospective absorption, which I claim. As such, the matter to be placed before the Vice Chairman. My lord, your lords may have a look at, my lords, page number 37. My lord, the Vice Chairman, my lords, the then Honorable Minister for Medical Education, type copy, my lords, is at page number 39. He says clearly, since the absorption is confirmed, she may be continued in INU. Specific words. Lord, it is also, my lords, approved by the Honorable Chief Minister, who happens to be, my lord, the Chairman. all along, they maintained that there is absorption, reabsorption of the, my lord, the complaint before lordships. I was asked to wait for issuance of the order. It so happened, my lords, one of the persons, my lords, who was absorbed along with me earlier, where my absorption in my favor was set aside, my lords, he came before the honorable court. Your lords may have a look at my lord's annexure G. Though, my lord, the government categorically said there is absorption, seniority to be fixed in accordance with rules. If your lordships kindly see, my lords, annexure G, maintain, my lords, silence before the learned single judge. If your lordships kindly have a look at, my lords, page number 44, para 5. Para 5, if your lordships have it, my lords, of the order of the learned single judge. For the first time, my lords, the state which was assuring me of the, my lords, reabsorption in pursuance of the order maintains the silence. My lords, your lordship may have a look at para 5. It starts, my lords, with thus, by virtue of the order of the division bench, the order of absorption had been made in favor of respondent number 4 number so and so on 8/12/2018 stood quashed, and as a further consequence, she continued to be on deputation and therefore was not in the category of respondent number 2 institution. The division bench of this court, though directed state government to consider the case of respondent number 4 for absorption in the category of assistant professor in accordance with law within a month, the state government has not passed any order of absorption. For the first time, my lords, I suffered an order, my lords, because of not passing of the order of absorption. According to me, my lords, the period of limitation, if any, my lords, started from the date of the order passed by the honorable court.
This page 30, page 40.
My lords, it's page number 40, my lords, the order.
It is in some other matter.
Yes, where, my lords, the other person who was earlier absorbed along with me, my lord, there was the same order. The absorption insofar as my case, my lord, that was set aside, directed to be reconsidered. Then a decision was taken by, my lords, the government and board, but no order was passed. He challenged the seniority which was given to me, my lords, by the governing council, saying that I have acquired the qualifications earlier to him. He said her absorption itself is set aside. No decision is taken. Hence, she continues to be an employee of the Health and Family Welfare Department, where she was working earlier, my lords, was his contention in that writ petition. As such, he said, I cannot be considered as senior to him. That was considered by the learned single judge of the honorable court.
This order is in. So what is the significance of this page 40 order?
Page, that is what, another, my lords, if I state few facts. Two persons, my lords, myself and this petitioner in this petition, we were absorbed, my lords, by a common order in 2018. That
8. Is of which date?
my lords, the
2023 August.
my lords, 8th February, my lords, 2018. my lords. It was the common order by which, my lords, both of us were absorbed from the date of that order. I preferred a writ petition, my lord, saying that I should have been considered from the date I was on deputation. That is from 2013, not 2018. The learned single judge found fault with, my lords, my claim on the basis that the absorption happened subsequent to me filing, my lord, submitting an affidavit before the authority, accepting prospective absorption. The single judge dismissed the petition, came up in writ appeal in 81 of 2020. There I made a submission that I'll forego my entitlement for absorption. Let them reconsider without giving reference to or without considering the affidavit which I have filed where I said I am ready for prospective absorption. Issue was remitted back. On that, there is an endorsement which I showed to your lordships on 12/5/2020, saying that you are reabsorbed. From that day till this, my lord, the order was passed by the learned single judge of this honorable court. I was, my lords, given to understand that I have been reabsorbed because seniority was also again fixed in my favor. My lords, I was sought to be promoted. My lords, throughout, I was, my lords, made to believe that I am the senior most candidate in the institution, considering the fact that there is an order of reabsorption. The learned single judge in this petition specifically held that as there is no order passed reabsorbing, I cannot be treated as an employee of the institute. For the first time, my lords, I suffered an order, my lords, at the hands of this honorable court to the effect that I am not the employee. My lords, my submission is, if there is any limitation which is to start, can start only from the date of this order where I was told by an order of the court that I am not absorbed. There is no compliance of the directions issued. My lords, the respondent, my lords, though raised, my lords, a plea insofar as limitation. My lords, how they are handling the issue even before this court, my lords, in this contempt petition, my lords, I'll, my lords, point out. My lords, in fact, my lords, when the petition was filed, the respondent, my lords, state filed, my lords, counter affidavit, my lords, insofar as my petition is concerned. If your lordships have, my lords, the counter affidavit, my lords, filed by the state in this petition.
My lord, my only submission is we are in contempt jurisdiction.
Yes, I'll show, my lords, how they, I'll take only 2 minutes and show, my lords, what their stand is before this court, my lords. Your lords may have the counter, my lords, filed by them before this court, my lords, in this petition. Para 9, they say, my lords, I'll read, my lords, from their counter.
There are 9 of
The counter filed by the state. Categorically, they say, my lords, in the counter. Para 9, if your lordships kindly see. Suppression of, my lords, all the orders, decisions, everything. Para 9, they say, I respectfully submit that the governing council had complied with the orders of this honorable court for which contempt had been initiated. Lordships got it. Their case is that there is compliance. They say, I respectfully submit that the governing council had complied with the orders of the honorable court for which contempt had been initiated. However, since there is an interstate dispute regarding the date of the complainant and seniority of the other similarly placed doctors in the department, civil litigations are pending in this regard. So their clear say is it has been complied with. There is, my lords, if there is reprobation, my lords, with regard to this statement. In, my lord, what is filed as the status report by the state. If your lordships have, my lord, the status report, what is filed. That is, my lords, it appears on 23/9/2024. If your lordships kindly come to, my lords, para 3 of the report. It's a matter of fact, my lords, after the writ, the order which I showed to your lordships, I have preferred a writ petition. Your lordships may kindly see. Para 3, my lords. I respectfully submit that the governing council meeting was convened on 18/6/2024. In the said governing council meeting, it was decided that the complaint was to be repatriated to the Health and Family Welfare Department. However, the complainant approached the Honorable Court in WP so-and-so, seeking for a direction for issuance of orders of absorption of the petitioner in service of the institute. He, as an assistant professor of nephrology with effect from 2/9/2013, as indicated in the endorsement dated 12/5/2020. First time they say there is an endorsement and there is such a prayer made.
where a writ is pending. Next paragraph. Para 3, my lords, I read to your lordships now in the status report. In the first counter, no mention of the endorsement. My lords, further they say, I respectfully submit that the Honorable Court in WP so-and-so on 25/6/2024 has passed an interim order as follows. That if a decision is taken in the governing council, it is made subject to further bid orders of the court, it cannot be given effect to. In view of the interim order, the respondent authorities are not able to comply with the orders passed by this court in WA number 81 of 2020. Lords, in the counter, they say we have complied with. In the status report, they say we have not done it. Lords, this is, my lords, is happening, my lords, for me throughout. As such, my specific submission is, as per their assurance itself, they are bound to, my lords, issue an order, which has not been done. No, my lords, I will take one paragraph, my lords, of the order which was clear case of, my lords, approbation and reprobation.
My lord, as I mentioned, this is a jurisdiction of contempt. So basically, my lord, I have only two
So
issues.
according to you, cause of action will start from which date?
From the
And
date
will
of the,
expire on which date?
from the date of the order, my lord, that is the order at Annexure A.
X-ray,
Yes,
what is that order?
that is the writ appeal order, which says at page 20, which says direct the state to consider the case of the appellant for absorption in the CADA not later than 1 month from the date which shall be communicated to the appellant. So, my lord, there is a delay barring the COVID period. There is a delay of 600 and odd days, which is more than 1 year. Therefore, the maintainability of the contempt is in issue and cannot be entertained. Secondly, my lord, with regard to the GC, there is a GC governing council decision which I would like to place on record. That is the recent GC order. This order, my lord, as in the decision of the governing council, dated 18/6/2024 at 5 p.m., chaired by the Honorable CM, my lord. The relevant page to be looked into is at page 37 of the English translated version. Page 37. The meeting noted that the words by transfer or in Rule 16A2 of the Karnataka Civil Services General Recruitment Rules 1977, Vide Government Order 2020, dated 6/7/2021, have been amended by deleting the words by transfer, and hence at the present, there is no provision to transfer from one department to another. Having said that, regarding the absorption of Dr. Leelavati V, in comprehensive opinion given by the Law Department, the meeting noted that as per the orders of the Honorable High Court of Karnataka dated 28/2/2020, that is the impugned order and from which the contempt is lies, Dr. Leelavati will have to continue on deputation only at the present. And since the absorption order of the said person has been cancelled, she will have to continue as an employee of the Department of Health and Family Welfare. The governing body has thoroughly examined all the above points and discussed at length and has decided to, considering the affidavit submitted to the court, that the service is not required by the Department of Medical Education and the amendment of Rule 16A2 of the Karnataka Civil Services General Recruitment Rules 1977 and the cancellation of the absorption with another department through permanent transfer, and the comprehensive opinion given by the Law Department in this case, that subject to the final judgment in the pending cases, the governing body has decided to return the services of Dr. Leelavati to the parent department, that is the Department of Health and Family Welfare, and has approved the action accordingly. So she's been repatriated, and the question of absorption and all that cannot be looked into, has been cancelled. So therefore, there is an endorsement, a decision taken. So there is a fresh cause of action, is my submission. And one is about the delay. The second is about the maintainability in view of the GC, which gives rise to a fresh cause of action. Having said that, my lord, in my compliance report, I have also mentioned as to how the GC, the same GC order or decision is subject to the writ petition in 12880, which has stayed the GC order. So, my lord, the contempt doesn't survive for consideration as my humble submission. And to base my arguments, I would like to forward the list of judgments, my lord.
Yeah, so before my learned friend says, no, this resolution is also under challenge.
Precisely.
One second, the learned, my lord, the said resolution, my lord, says under challenge in WP 24057 of 2024. The order, an order is passed by my lord learned single judge in WP 12880 of 2024, restraining my lords the state and the governing council in giving effect to the resolution which has been passed, because there is clear suppression of my lords again the my lords endorsement on 12/5/2020 and my lords all subsequent developments fraudulently, my lord, this is issued.
My only submission is because it's pending before the writ petition, this contempt proceedings would not survive for consideration. That is one. First is, of course, the delay, then the maintainability as to whether this will survive in view of the GC, and the GC being subject to a writ petition, this contempt will not survive for any consideration before this honorable court. And for that, my lord, I would like to, in my written submissions, I have based my reliance, lordship.
Only one answer we want, page
Please.
20, page 20.
Page
20.
20, please, 20.
Clause 5. It
Yes.
says that the decision shall be taken by the state government
With
Not-
regard,
not later than 1 month from today, which shall be communicated to the appellant. Now, when it was communicated?
the GC, my lord, the GC which I placed before your lordship, that is 18/6/24,
18.
that is the communication wherein we have said you are being repatriated, and the question of absorption and giving you, taking you
According to him, the 1 year period will start from that day.
from the date of the GC order.
This order when you communicated.
In contempt, my lord, contempt starts, the clock starts ticking from the date of when this knowledge of this aspect came to him. And that knowledge, my lord, in the representation, if you look into the representation at Annexure B, 15/11/2022, whether there is a contempt at all, when we have considered it, the knowledge is important. 15/11/2022 is the representation given by the complainant. And the clock starts ticking after 1 month from the date of the decision.
What about your obligation?
Pardon me, my lord.
Clause 5 cast obligation on the state government
Please, my lord.
to take decision.
We have taken the decision as my submission.
If the decision is not taken, then it will go on continuing or not. If the decision is not taken and until not communicated, the limitation would extend or not.
No, it will not extend, my lord. They should apply for contempt within 1 year from the date of the order. After that 1 month of,
Lie if it's a lie,
not later than 1 month from today.
contempt of court. Yes, ma'am. Contempt of court, section 20. From the date on which the contempt is alleged to have been committed.
Please, my lord, that is 1 month from the date of the order.
All right, we'll give the.
There are decisions with regard to
There is a decision by governing council has been communicated to him refusing the absorption. Is understood. So that not a decision.
my lord, I have relied on a couple of judgments.
Lie
my lord.
judgment, maybe आपके judgment. दिए ना? Where is your judgment? These are your judgments?
Written submissions are given.
Yes. Now we heard, last time also we heard.
Yes.
My lord, this is, Pallav said was as to the concept of section 20. And then Tirupati Rao goes into as to continuing wrong.
Pallav
Cannot
said-
be accepted mechanically.
Where is Pallav said lie? That is vis-a-vis to section 20 vis-a-vis.
Please. And then Tirupati
This
Rao.
Pallav said is the last law.
No, after that is Tirupati Rao. That is the recent law, as in the recent judgment, 24, decided in the year 24. And the relevant paras, my lord, I have put it over there. And then I have also relied on Lalit Mathur, wherein it says that in contempt, merits cannot be looked into and a roving inquiry cannot be done. And if periodic representations are given, that doesn't,
22nd. For orders. Now arguments over, we also understood.
Only one submission, my lord. Specific direction in the writ appeal is, my lords, against the government. My lord, they are now, my lords, bringing before your lordships the resolution, what they claim as of that of the governing council. Admittedly, my lords, the government has not communicated.
We'll consider.
if repeated representations are given, that does not extend the period of limitation under the Contempt Court Act, my lord.
Please.
Much obliged.
The Vidulata? For the complaint in this matter, my lord.
According to order is complied.
But the order is not yet compliant, my lord. My lord, they have given the endorsement, my lord, stating that it cannot be considered, my lord. It cannot be considered, my lord.
Why?
My lord, it's annexure D, my lord, kindly at page number 69, my lord.
9.
That 69, my lord, that draft kata has been issued, my lord. My lord, the order of the single judge, my lord, was passed on, my lord, on 30th August 2023, my lord, which is at annexure A, page number 14, my lord.
Where is the new order you passed?
My lord, that is the endorsement.
Page
The page number 5,
page number 5.
English translation 7 and 8.
22/8/24.
With the reference application also, at cases before the honorable court so and so. So submit application along with relevant document. Gram Panchayat and so and so. At general meeting after discussion pass the following order. That complete order, what is passed, my lord, is stated. All the applications so and so are rejected for the above reasons. If so and so, 5 fresh applications for issuance of individual copy in accordance with law to obtain permission from planning authority, I will be concerned.
Lord, this is order, the same order which has been passed
This
earlier,
endorsement
my lord,
issued.
which was rejected by the
My lord,
honorable court. on
direction is
38,
issued by this
24.
honorable court to the Gram Panchayat to consider the application, the third respondent.
This court had an occasion to pass. It is over. Order on 19/8/24 agenda. Then 19/8/24 Pura order. Today when the proceedings came up for consideration, learned advocate for the respondent invited attention of the court to endorsement of the order dated 22/8/24. It is filed along with affidavit. Affirmed by the Panchayat Development Officer, Bengaluru Gram Panchayat. Accordingly, fresh order is passed and the author and the authority which has passed the order is also clearly indicated. When the order is passed by the competent authority, the directions are complied with, it is not possible to accede to the submission on part of law and order with so and so for the petitioner that the contempt still survives and that there is no compliance. The contempt proceedings are closed. However, it is observed that if the petitioner has any grievance on the merits of the endorsement of the order dated 22/8/24, it will be open for the petitioner to institute independent proceedings to challenge the same in accordance with law. This court does not express anything on merits about such recourse.
Number 104.
I appear for the complaint, my lord. Lord, this matter was. The state in the matter, my lord.
104.
Lord, this matter was kept at 2:30 on last occasion, my lords, because your lordship directed the state either to report compliance or keep the officer present orally, my lords. My lord, the order of which disobedience is alleged, my lords, is annexure A, page 11, my lords.
There is no order requiring the officer to present. Where is the order?
My lords, orally, my lords, orally, your lordship. That is why it was kept at 2:30.
Orally may say anything. Is it true?
Please, my lords, I'll just convince. Your lordship may kindly see annexure A, my lords, page 11.
My colleague appeared.
Attend the oral versions of the judges, then the court will not function.
My instructions are, my lords, writ appeal is directed now to be by the
Orally,
government.
we are prone to say many.
Yes, my lords. Writ appeal is to
My lords, the order of which disobedience is alleged, my lords, is at page 11, my lords, annexure A. 2 weeks' time is what I request, my lords, for the reason that we are filing an appeal as against the order.
Where are the, what is the complaint?
My lord, Annexure A, page 11, my lords, for a moment.
Page
11, my lords.
11.
This is the order, my lords. Your lordship will see
But
the,
where is the operative part?
my lords, before that, my lords, for a moment, my lords. Page 11, your lordship will find the name of Uma Devi, who is the complainant before my lords. If your lordship turns over to the next page, my lords, your lordship will find the connected writ petitions, name Siddhappa, Borama, Basavaraja, and others. Then, my lord, the operative portion of the order your lordship will get at page 20, my lords, 20. My lords, the issue involved
yeah.
in
Yes, read.
the issue involved in these writ petitions is with regard to consideration of the case of petitioners under deemed regularization, and the same was dealt by this honorable court in WP 3672 of 2021 and connected writ petitions disposed of on 5/4/2023. In view of the matter, the contentions raised by the learned counsel appearing for the petitioner is accepted in the light of the observations made by this court in the aforementioned petitions. Accordingly, the writ petitions are disposed of. Now I will take your lordship to the order passed in WP 3672 of 2021, which your lordship will get at Annexure D, my lords, page 56. Annexure D, page 56, perhaps. Lords, the operative portion of this order, your lordship will get at page 84. Lords, after a detailed analysis, my lords, this court has held that the respondents are directed to consider the petitioners as deemed regularized employees. There is no discretion left to the authorities. It is the positive direction to consider them as deemed regularized. Then your lordship will kindly see. May I take your lordship to page 99, my lords. The order is complied in respect of all the writ petitioners.
Yes.
Yes, my lords.
I recollect.
Yes, my lords. 2 weeks' time is what we had requested, my lords, on the last occasion. My lords were pleased to grant us time till date. Writ appeal is filed wherein for this reason, my lords. My lords may kindly see page number 84, where the honorable single judge directs that as per the orders passed in writ petition 50876 of 2019, this order also follows. My lords, of course, the honorable single judge has considered everything, but the fact remains that in the other order, which is referred at 50876, they take recourse to Uma Devi's case and say that in compliance with Uma Devi's case, if they are falling under, they should do it.
No, they have complained that.
There is some ambiguity where we wanted to prefer an appeal and get that clarified, my lords. I'm told my instructions are by today, tomorrow, the appeals are filed, my lords. Next week, any day, my lords, may make this request, my lords. The appeals, as and when today, tomorrow, we'll file it, my lords. I'll bring that before my lords, my lords. Together, my lords, may.
I'll appeal, but
No,
subject to outcome, you must
Please,
reinstate. Is it reinstated?
Lords, they have
what has
attained
happened?
superannuation, lords. They are only for seeking for retirer benefits.
They've all retired, they've all attained. They've all been superannuated, my lords. Only retirement benefits.
Then you are on a bed. Appeal is filed or not?
Not filed.
The reply, my lords, the appeal is for to be filed today, tomorrow is my instruction.
In respect of similarly placed writ petitions, my lords, your lordship may kindly come to page 99. They have complied with the order. They have issued orders. And now, my lords, they are issuing an affidavit saying that it is not permissible under rules, as if they are the division bench. Issuance of the endorsement now, my lords, by way of this affidavit is amounting to aggravated contempt. They are not the division bench, my lords. When this court says consider them as deemed regularized, if they had to file appeal, my lords, immediately they should have chosen to file appeal, not after receipt of contempt. And this honorable court directs them, report complaints. They cannot say now that they are going to file appeal at this point of time. And very issuance of endorsement, my lords, by them has amounted to aggravated contempt. They'll have to withdraw that endorsement forthwith.
Uma Devi is retired.
My lords, she has retired. She attends.
Plans should be what?
Dispersal of retirement benefits. By treating her as deemed regularized and other pensionary and other consequential service benefits, which has ensured to all other employees who are placed similar to that of Uma Devi. That is what I pointed out, my lords. Along with Uma Devi, there were other writ petitioners also at page 11, my lords.
At page 12, I pointed out to your lordship, at page 12, along with Uma Devi, Siddhappa, Borama, Basuraju, Sanna Bora were other writ petitioners. They have been disbursed with retirer benefits. If your lordship turns over, if you
Where is the name of Uma Devi not given benefit?
please, page 99, notes, page 99. They refer to the case numbers at bottom. Furthermore, this honorable court in writ petition number 3672, 3468, 9573, so and so has ordered that all service benefit due to the employees as per the code be provided within the time frame. Then, if your lordship turns over to next page, my lords, page 102, my lords. At serial number 16, page 102, your lordship will find the name of Siddhappa, Boramma, Basavaraju, Sanna Bore, who are part of the very same writ petition. Page 102, my lords. My lords, Siddhappa is writ petitioner in WP 253, page 12. Part of the very same order of the learned single.
Siddhappa, yes, Siddhappa was not.
Siddhappa, Boramma, Basuraj are all.
Siddhappa also retired.
They all retired. They have given at page 104, they say we have complained. Now, I will point out, my lords, when Siddhappa retired also. If your lordship comes to page 111, my lords, 111. Now, if I take your lordship to page 111, my lords, 111, my lords.
Write down 2 writ petitions. Bearing number 3461 of 2021 and 253 of 2021. Came to be disposed of by common order. Dated 6th April 2023. Passed by on a single judge. The order reads as under. Page 20, bracket, the issue involved, 5/5/4/23. In other words, after quoting, the 2 petitioners of the aforesaid 2 writ petitions were to be extended benefit as directed by the court in the order passed. In writ petition number, in order passed on, in order dated 5th April 23, passed in writ petition number 3672 of 2021 and allied petitions. The directions in the said order dated 5th April 23 to be applied to the case of the present petitioners. Read as under page 84, bracketed portion. Respondent authorities are directed to consider from the date of receipt of this order. As was demonstrated by learned advocate for the petitioners, out of the 2 petitioners named Uma Devi of writ petition number 3461 of 2021 and one Siddhappa, who was the writ petitioner in petition number 253 of 21, the order, the directions about regularization were not implemented in case of Siddhappa.
No, my lords, in case of Siddhappa, implemented, my lords. Only in case of Umadevi, not implemented.
Okay. In case of Umadevi, not
In
implemented.
case of all other writ petitioners, implemented. Only in case of Umadevi, not implemented.
So Umadevi, Siddhappa and
Others.
Siddhappa and other 22. So the directions regarding regularization was not implemented in respect of Umadevi,
Yes.
petitioner Umadevi. This fact is borne out from official memorandum dated 22/5/23. Although it states that the orders issued by the High Court in the writ petition number 3672/2021 and other connected writ petitions are acted upon, and the temporary pay employees are regularized with effect from the date of completion of 10 years of service, comma. The said direction and compliance was not extended to Umadevi. It is in that light paragraph, it is in the above light that the present contempt arises. Yes.
Notes, kindly one request, notes, page number 54. The directions which were followed in writ petition 3672 was like this, notes, may be permitted to read page 54. Writ of mandamus issued to respondent deputy commissioner to consider the case of the petitioner for regularization of the services in terms of the directions of the Honorable Apex Court in the case of Umadevi, order dated 25/5/2006. There were two conditions in Umadevi in 2006, Lord, that there should be a sanction post as against which a person should be employed on a contract basis, and 10 years of uninterrupted service if they have completed, only then they should be regularized. Now kindly, my lords, permit me to read my counter affidavit which I have filed. The endorsement will indicate the translated portion at page 6, my lord. I filed it on 19 September 24. Affidavit along with annexure R1. Page 6, the second portion of the endorsement, my lord, in government order dated so-and-so, dated 6/8/1990, all the appointments of daily wages employees made after 1/7/1984 have been cancelled. Further, backdoor entries of all types of appointments have been prohibited as per the judgment of the Honorable Supreme Court in Srimati so-and-so. Our Honorable Court in its judgment has allowed regularization of daily wages employees who have completed continuous 10 years of service on daily wages, subject to certain conditions as one-time measure. It is stated that in the government circular dated so-and-so, since daily wages employees who are appointed after 1/7/84 were continued in service due to the orders of the Honorable High Court on so-and-so and so-and-so. Hence, such daily wages employees who have not fulfilled the 4 conditions prescribed in the Honorable Supreme Court, conditions that is 10 years of continuous service, so on and so forth. Subsequently, in the next page, we have indicated as to how a subcommittee of the cabinet was formed, and then they have gone into, and they have found that the services of these employees who have not completed 10 years could not be given this benefit.
Admittedly, all of them have completed more than 3 decades of service, my lords.
The last paragraph, notes, in view of the honorable direction of the Honorable Court, High Court in so-and-so, as per the above government order and circular, request has been examined. Since you have appointed as daily wages employee after 1/1/86,
In response to the contempt petition, affidavit came to be filed by one Nagesh K, son of Birahia, EERAIAH, stated to be serving as Under Secretary to the Government from Urban Development Department, Bengaluru. In the said affidavit, it is claimed that the directions are complied with. Further, the deponent has produced endorsement, public order dated 6/9/2024, in which he has proceeded to deal with the directions of this court. In the writ petition number 3461 of 2021, read with those passed in writ petition number 3672 of 2021. The undersecretary to the government who has affirmed the affidavit has shown audacity to call in question the efficacy of the directions, legal efficacy of the directions passed by this court on various grounds. In the contempt proceedings, such aspects are not relevant. What becomes relevant is the stand evinced by the said undersecretary, who is the author of the endorsement of the order dated 6/9/94. According to the court, according to this court, the said order of the endorsement, insofar as it opines to deny the benefit to said Uma Devi on the ground stated, is an affront to the court's direction, and contumacious. Full stop. However, an opportunity is given to the said authority to cure the contemptuous conduct on his part before any further action is taken. It will be open for the said authority to take remedial action. Public pass remedial order before the next date of posting of the present proceedings. Another aspect which emerged and submitted in course of the hearing is that the respondent intends to file appeal against the order under contempt. The present contempt proceedings has progressed and advanced. Has progressed long and is in an advanced stage. Still, however, not still, however, full stop. It is at this stage that the submission is coming forth, that the appeal is decided to be filed. Although it is an admitted position that the appeal is still not filed. Be that as it may. Paragraph. While the respondent may have right to file appeal and such opportunity may be allowed to the respondent to file the appeal, comma, it is provided that the benefits which are payable to said petitioner Uma Devi, who has already superannuated, comma, shall be calculated and shall be deposited with the registry of this court within 3 weeks from today. Full stop. Put up for further orders, put up for further consideration and orders on which date after 3 weeks? 10th of December. So you may prefer appeal, but deposit the amount.
Please.
And we have called upon your secretary to explain his conduct.
Yes. The order is of 6th April 2023, my lords.
The endorsement, Badati and endorsement 6/9/24. The endorsement dated 6/9. He said endorsement dated 6/9/24. In its last paragraph, reads as under, and quote in view of the direction, page 7, to service. Thus, it is clear that said Uma Devi is denied the benefit, denied the implementation of the order and the extension of benefits thereunder on the ground that he was appointed after 1/1 in 1986. However, the list of the other employees which are mentioned in memorandum dated 22/5/23 and who are extended the benefit go to say that all were
Appointed.
of them were appointed before 1/1.
Lords, no, all are appointed subsequent.
After 1/1/86. So, prima facie, the stand of the deponent, even on merits, is not acceptable and amounts to discrimination and a clear contempt of the court.
It's an act of aggravated contempt. They cannot
But
sit in
you
appeal.
are singling out that
Understand,
person.
The next matter also connected matter is.
You
also-
can pass, you can pass press order, remove your, cure your, remedy your conduct.
Please.
And then whatever you do.
The next matter also pertains.
Same, my lords, here
Same.
also.
One other person.
Next is same.
Please.
Next, my lords, if your lordship sees annexure A, page 9 is the order.
Yes.
Here, my lords, except for petitioner number 2, that is Syed Shawar Rahman, for all others, they have complained. Except for petitioner number 2, they give the send off. Same.
So same order will pass.
Same.
Give that order, then I'll give correction. So if you're able to pass, then pass.
Oblige.
Any date, my lords, may seek indulgence for a date, my lords, after 3 weeks. A date, my lords, for
10th December,
deeply.
already given.
Deeply.
Only request for the copy of the order below so that they can
I will
communicate.
give tomorrow.
Please.
Cell number 106, Mr. Varsha R. Iyengar. Cell number 106.
How much, how many are? One. Yeah. Nobody who will appear.
This pertains to appointment of special teachers for the visually impaired students.
Read the petition. You file reply.
My lord, I have filed, but since it is a old petition, my lord, may I seek my lord's indulgence to file an affidavit bringing to the notice of my lord, what is the present status as on date?
Now, this petition will assume importance in light of the recent judgment
Yes,
that accessibility is a fundamental right. Accessibility for the persons with disability. We would include the persons with or children with visual disability.
yes,
They must have access to all means of education, textbook, learning, teaching is a part of fundamental right. Recent judgment. Very
Could I-
recent judgment, last week.
could I look into that and I'll. Have, visually impaired.
When shall we keep? Who appears? What?
Shrimati Varsha R. Iyengar.
This will keep on 19 for the time being.
My lord, I'll come up with an affidavit. My lord may give me third or fourth if
We'll keep it after on 19. We'll further adjourn.
Very well.
But for our
Yes, yes.
memory purpose,
Yes.
19. 19 to be listed at 2:30. Remember not to be agree, but just keep it.
Yes. Bill number 107. Vishwanath Shetty V. Appellate's counsel.
Oh, election. Election? No.
None.
The appellant before your lordship is a company.
Company.
It had filed a specific
that
relief,
Last time, Lord, I had
suit for
pointed out.
specific relief. It was pointed out that registration is cancelled under 248.
He has gone in liquidation.
No, not
Company's name
liquidation.
itself is struck off.
248 under 248 name is struck off,
On the
which would amount to cancellation of registration. Against that, my lord, we have preferred an appeal before the national NCLAT and a notice has been ordered. That apart, your lordship may kindly see section 250 of the Companies Act, my lord.
Like.
Sorry. $250.
Please.
Liabilities, obligations of the
Where a company stands dissolved under section 248, it shall, on and from the date mentioned in the notice under subsection 5 of that section, cease to operate as a company, and the certificate of incorporation issued to it shall be deemed to have been cancelled from such date, except for the purpose of realizing the amount due to the company and for payment or discharge the liabilities or obligations of the company. In the instant case, the company is seeking for an asset which can be ascertained in terms of money. My respectful submission is even this the word realizing the amount due to the company, it would include even the assets due to the company. I have sought for specific performance of this thing. And as your lordships know, my lord, under the specific relief act, court can even award, in lieu of specific relief, court can award the compensation or even earnest money, etc. For that, the section itself provides an answer that it can be claimed at any point of time. Section
It is not claimed.
21 or 22.
Claimed. This is, my lord, an MOU.
But apart from all other things,
Specific
what I bring to your lordship's
say
notice
JDA.
is, we have preferred an appeal before the.
No document is produced. 4 times.
Yes, sir.
Against 248.5 order, 248 order.
248. Your lordship may kindly have the appeal is registered, and actually, I don't have the exact date. Last week, notice is issued to the.
ಅಲ್ಲ ಇದು ಬರೀ ನಂಬರ್ ಅಪೀಲ್ ಮೆಮೊರಾಂಡಮ್ ಏನಿದೆ ಅದನ್ನೇ ತೋರಿಸ್ತಾ ಇದ್ದೀರಾ.
We have filed the appeal, and I am told, my lord, I don't have the exact date. Notice is issued to ROC calling for this.
Order sheet is not produced, appeal memorandum is not produced.
We admit this appeal.
We should place that immediately.
Let the suit is on the basis of an MOU to execute a JDA, not for execution of the sale date. To execute a JDA, JDA itself is not there. This company has no transaction. They cannot execute the project at all. The project is that they have to develop the property. Company is struck off, no transaction, no money.
Company has paid 2 crores of advance.
Crores you have paid, that is all. Nothing is other. Total is there.
Within 3, it is not that easy, Mr. It is not that easy that your argument may go through. Because.
Of course, my lord, the court below has rejected that claim for refund, giving some reason, but I am in appeal before your lordship. I will be able to pursue. The refund of amount of 2 crores is refused.
If you want only refund, my lord, that we can consider it. They have not claimed that refund. If it is only a question of refund, because I want to develop the property, nearly 20 years are over. Now he wants to develop the property.
Actually, it was a suit filed in the regular civil court. It should not have been transferred to commercial court at all.
It's not question.
That argument,
accepted.
now it cannot be advanced at this appellate stage. So this is the only ground on which the suit is dismissed.
No, it is on several grounds. One is, my lord, it is only based on MOU agreeing to execute a JDA. No terms are mentioned.
This is one of the ground also.
And that is also another ground. It is one of the ground. Another ground is an agreement to execute another agreement is not, cannot be specifically enforced because parties have not arrived at any understanding. Their prayer is to execute a JDA pursuant to MOU. Such a thing cannot be executed. Secondly, the court has also given a finding that they don't have the funds because the party, there is no transaction. They did not produce any of their balance sheet or anything. No transaction, no money is with them to develop the property. It's a huge property of around 15 to 18 acres, which they are required to develop, put up construction. This company's name is struck off. No money is with them. The court also said that they are not ready and willing.
It's the first appeal on all those grounds, my lord.
If not maintainable, then why should we?
Maintainability, I will produce even that court has, NCLAT has directed,
Another
has
thing is,
issued
Lord,
notice.
agreement is with private parties. After that company is formed, if the company is formed after the agreement, they should accept.
No, once the registration is cancelled,
Please,
245, 248,
248.5.
the company would lose its status as separate entity. Except for the purpose of realizing the dues. That is not amounting to making, the company as a person will not be a person. There is an illegal personality with the company, once the registration is cancelled. So how the
appeal
is maintained?
That is the exemption granted in respect
Exemption.
of realizing the assets and discharging the liability.
Where is that liability? Where is that amount due?
It is, my lord, the very development of this property itself is the amount, asset.
Bring some judgment on the scope of section 250, then we'll consider. Scope and purport of section 250, in what circumstances apply, what is the scope, then we'll consider. Otherwise, prima facie, they appear to be right.
And my lord, the appeal, who is the authorized signatory? How have they filed the appeal? Not even a note in the cost title. Company is not in existence. Clearly, they say appeal is
That
filed.
is what we are pointing.
How, who has signed it?
exact. So bring some judgment, both of you, on some.
That we are ready. If they are willing, whatever amount
No,
they
no.
have.
Some judgment in respect of this.
That I'll produce.
Yes. 21st at 2:30.
Not at 21st, my lord, it may be on 26th or 27th.
26th,
Please.
26th.
Please. NCLAT,
At 2:30, my lord.
2:30. Lord, 26th at 2:30. Pardon? 26th at 2:30.
This is the, this petition to be admitted, then it will not take time. Please be decided, then also it will not take time.
Yes.
Therefore, 2:30, yes. Give me. Okay. What are the matters left on?
Up to 5 you can do. Up to. Hopefully.
Number 44. The Prithvi Odia.
What happened to 41, 42, 43?
Open for petitioner.
Yeah. Government advocate. Reading.
The Lordships kindly turn to the order dated 27/6/2024. It was an undertaking given by the government so that they will, the bund is removed
Government advocate, madam.
on 27/6/2024, Your Worship.
Who appears?
Page 30, photographs.
There is no urgency as such. Today time is over. So let it go to 4th December, 5th December. Next.
In the meantime, there is an undertaking given In the meantime, let the government pursue this matter before pendency of this.
What is the
petition.
undertaking?
Undertaking is that they will clear the
Here, who appears, Mr.?
the authorities to
Negre.
ensure that the bund is removed and the lake area is kept made open.
Non-respondents, ನೀನು? ನೀನೇ.
Not done so far. But, day after tomorrow at 2:30.
Saraswati? 46?
That's, in this, I challenge the order passed by the first respondent, my lord, for issuance of marriage certificate by the work board. I challenge the order issued by the first state, my lord, for issuance of marriage certificate by the work board, my lord.
Page 45 is the notification, is the order.
Sorry, my-
Page 45.
please.
So what is the grievance?
My lord, this order, my lord, the High Court of Karnataka at Kalburgi bench, my lord, it has passed an order that to inquiry whether the work board is, Kazi is authorized to give
Is this
the,
petition for?
it was challenged it was challenged for that Kazi can authorized to give the marriage certificate, my lord. My lord, page 63, my lord, the last para, my lord, typed copy of that order, my lord.
Para?
Last para, my lord, 63 page,
Page 63.
please.
Who is second respondent?
Sorry,
Second respondent is
work
who?
board, my lord.
Wakaf board.
Okay.
Second, where is that title, your title of the petition? Who approves? Karnataka Under Secretary Minority Development Wakaf Department. By order of the third respondent, second respondent has been authorized to issue marriage certificate.
According to-
1 and 2 state appears, my lord. Third respondent has to reply. That is the board. Ms. Anuradha appears for,
You are appearing?
I appear for 1 and 2, my lord. Third respondent, Mrs. Anuradha, the senior counsel. As in, I think her office. This is the government order. My lord, we will need to file our objections to this because the there is a government order under challenge. We'll need to file our objections in this matter, my lord.
You file your objection.
We'll need to file our objections
You
because
file-
annexure A is
File before 20th. This is unheard of in law.
end of this month, my lord. End of this month, 2 weeks time.
What endorsement? This 30th 9 order
Yes,
at page 45,
yes.
which authorizes the Waqf board to issue marriage registration certificate, is unheard of. To show the power under the Waqf Act
Please,
to
my
issue
lord.
the marriage certificate.
2 weeks time, my lord, I'll have.
No,
the
not
objection.
2 weeks. No, in this matter, be clear. 20th will grant time. 21st will up to 21st to be listed on 20.
Please,
To be listed, the petition shall be listed on 21st of November at 2:30, before which date the state shall invariably file its response.
much obliged.
Yes, next. Next.
Yes, PA. So Rajaram, yes?
For any urgency? Yes.
Respondent number 7 and 8 are running, my lord. Then waste processing unit, my lord. Respondent has to take action against the concern, my lord. How many schools are,
Here also no replies, nothing is filed. They have filed some response.
we have filed? No, my lord, not filed any of them.
The response shall be filed before the next date, put up on 9th December.
Much obliged.
I'm in a very vulnerable position, Lordship. The serial number 78. My house is getting destroyed tomorrow. Today they have even destroyed this. This is a government property. In the guise of an order of the Tahsildar, who is not supposed to pass an order in such a way. It is a private property, and the Tahsildar has passed an order.
It is under office objection. You remove the office objection.
Lordship, yesterday I had tried my level best to complete the office objection. Unfortunately, I could get the file only the fag end of the time.
So when do you want? Tomorrow?
Lordship, they have tomorrow,
Day after tomorrow?
because I think tomorrow I'll be able to get the file in my hand.
Day after tomorrow.
But here, Lordship, my humble submission is, if I do not get any help from this Honorable Court, because already the law and order has been compromised, nobody is helping.
First you help yourself by removing office. Then we'll try to help.
They have tomorrow.
My lord, serial number 77, my lord. There was an office objection raised by the office.
Pending office, pending.
No, we have complied it, and even this honorable.
Learned counsel states that he will comply with you.
No, it has been overruled by this honorable court.
On or before 14th of November. However, he places urgency. Therefore, the petition shall be listed. Appeal, contempt petitions will be listed for consideration on 14th 11.
My lord,
My lord. So last time they have agreed to, instead of site, they are going to give the compensation. Today they have not come, already 2 years over matter.
Which one?
Contempt, serial number 60. Serial number 60.
19th.
19.
my lord, serial number 77, my lord.
19th. 19. It will come with contempt.
My lord, serial number 77, my lord. There was an objection raised by the office. Annexure C was not forthcoming. It was explained to this honorable court, and the same was overruled. Again, it has been listed for non-compliance, my lord. Kindly, I request this honorable court to proceed for admissions, along with the connected matter 893 of 24.
No, you comply with what?
No, we already complied, my lord.
Learned counsel states that, which is the number?
Serial number 77, my lord.
77.
77.
Primary counsel, Mr. So-and-so said
For
that
kindly
the
post for admission, my lord.
Therefore, the case may be put up for consideration at the admission stage after 1 week.
My lord,
Serial number 55, my lord, it may be
Al-
taken up any day, 30, my lord. Serial number 55, my lord. I'm appealing for the responding, my lord. The petition, my lord, is regularized, my lord. In the similar petitions also, it's regularized, my lord. It may be taken up any day, 2:30, my lord. Petitioner working from several years, my lord. Their service have to be regularized, my lord.
Your Lordship passed an interim direction directing the university to regularize. That has been done. They have sent it to the government, Lord. Only thing, the government signal is required.
Take a day.
Any day, my lord, 2:30. It will not take much time.
55.
If the government rejects, then the matter has to be heard. And within the university budget resources.
23rd.
Much obliged. My lord, serial number 49, my lord. At serial number 49, my lord, there was a writ petition in the, before the single bench judge, my lord. However, there was a writ appeal here at 49. Because of that, they were asked to refer the matter here, my lord. But writ appeal does not survive anymore because it has become infructuous. I appear for respondent in the said writ appeal, my lord. A short date may be given so that it may be submitted and writ petition can be referred back to the single judge bench, my lord.
It is infectious.
Writ appeal, it does not survive any longer, my lord, because it has become infructuous. So the writ petition which has been referred to be clubbed with writ appeal needs to be referred back to single judge bench, my lord.
Day after tomorrow.
Much obliged.
We'll examine whether it is what you are saying is correct.
Much obliged, my lord.